Lordship, Lordship, may be permitted to mention these two matters. My lord, these two matters may please be kept under to be mentioned. I would want to withdraw. My lord, the client has given me instruction to withdraw this matter because of the mistakes involved in the petition.
My lord, this is a review application. My prayer for inclusion in the list. Review.
Lordship, on urgent motion, my lord. Lordship heard the matter at length by Mr. Parthasaji Bhattacharya appearing for the petitioner, my lord. That lease matter, my lord. Matter to be taken up next day, my lord, but matter is appearing item number 78. Lord, kindly take it up any day, my lord.
78 in the supplementary list.
Lord, kindly take it up any day, my lord.
Yes.
May I take leave in
Lordship.
petition, Lordship? The urgency is that, Lordship, next week
Please indicate the urgency hand over this.
Item numbers 97 and 98.
matter, Lordship. So that you, Lordship, can heard this matter tomorrow or day after tomorrow, Lordship.
Please file it, give the date, it will appear.
And item numbers 97 and 98 of today's list. That will T corner matter, Bidhan Nagar, Mr. Mukherjee.
Yes.
That has gone down a little. The
97, 98.
98. My client is absolutely without any job now, for months together. And what is shocking, we have already indicated that the petitioner, what he is blaming us, he is doing the same thing.
All right. Please hand over the slip.
We have mentioned on notice.
Similar compensation
Right.
for inclusion in the list.
Inclusion.
Yes.
Motion.
New motion. May I permit to mention old contempt matter inclusion in this?
With your permission. So there was a review petition here. It is being transferred from the bench. You had heard that in the FMA 559 with the Chief Justice. Now it has come for a review petition in your court with Justice Om Narayan.
Please,
So
hand over the slip. Please hand over the slip.
I didn't bring the slip. How do we? I have to give you the slip.
Yes, please
Okay,
mention
I'll
the
do-
slip. Give the number that it has been assigned. Review.
I'll do that. I'll do that tomorrow. Thank you.
Yes. Number 1.
Petitioner, this is the affidavit of service. My lord, your lordship has been pleased to extend the order from time to time.
Yes, who is for the other side?
My lord, I have served, and also I have served after mentioning also. I have served the extension and I have served the after mentioning the letter. My lord,
This application is for extension.
yes, your lordship kindly, my lord, extend and fixed a date, my lord. It expires, my lord, in the month of December, but
So,
we have filed
this is an
before
assigned matter.
assigned matter
The interim order is still.
till December. We have filed before that.
This is an application.
Deeply obliged.
disposed of. 10-4. Next.
My lord, item number three is my application. May the affidavit of service be taken on record.
Yes, what is this matter?
My lord, this pertains to a complaint of a mass petition of almost 18 people where they have stated voluntarily that I am an enemy national and therefore the property that I hold, including properties of a Waqf deed, the deed made in 1935, is a enemy property.
Mass petition is for declaration that the property is an enemy property.
Enemy property.
Now, what has been done after that?
Now, my lord, may I indicate that my lord kindly takes up the petition, the mass petition. The complaint is at page number 43.
No, any inquiry has been initiated.
Inquiry initiated not by the district authority, who is empowered. My lord, kindly sees the order for the inquiry.
95-96.
Page 96.
Page 95-96, Lordship may have kindly have a look at, Lordship. So I'll have to take update on this, what has happened.
Your Lordship, just matter on merits, but your Lordship kindly peruse page 6, paragraph 5. And several paragraphs, they have made allegation, private respondents, no private respondent have to make that.
I am coming to that. Primarily,
Wabur is not a party.
my lord, the order for the inquiry has been made by Additional Director of Land Records
But it
and
is at the
Surveys.
instance of some complainants. Why have you not implemented them? You have annexed the mass petition.
My lord, then may kindly give me leave to implead all 18
Yes,
people.
because you have made allegations because it was at the instance of some private parties. This mass petition.
My lord, may
You also have a right to contest this.
my lord, may kindly give me leave.
He's saying, my lord, since he's take a rep.
Paragraph 5, 10, 16, 11, 12, 17, 20. Several paragraphs.
The only reason,
Since the petition is taking reference to WAP property, so WAP board is also a necessary party. They will have to come and say whether this is the enrolled property or not.
First paragraph, yes.
Where is the allegation with regard to?
First paragraph.
The very first paragraph, Lordship kindly see the very first paragraph of the writ petition, my lord.
First paragraph of the writ petition.
Writ petition. Petitioner further stay, he is also managing the Chakpalta WAF state enrolled on the WAF board with the EC number so and so, so and so.
He is the man, he is managing, but whether that property is also the subject matter.
Yes, my lord, he says.
on
Well,
one
the
jail
estate.
number.
Yes.
One jail number out of 3 which has been complained of is
So paragraph 1 and
Board is also a necessary party.
but I'll implead and come back.
Chief Executive Officer to a
Adequate
party.
এটা অন্য
Okay, preceding the rest. Yes, item number 4.
Back to the private respondent.
Matters relates to encroachment, Lordship, kindly come to the
Encroachment of what?
government land, Lordship. In this case has been blocked, Lordship, P4, page 61.
What?
It is a
Kindly-
I'm for the private land, private respondent. If it is
Private
a
respondent.
lordship, if it is in over the government land, then it should go before the public premises eviction act.
No, government, it says road, highway.
Responsibility road,
No, but
Lordship,
it is
it
a
is
government land.
page
I have also
P4,
prepared a writ petition challenging this order of
that will appear along with this writ petition.
which is
Kindly-
appearing as item number
Wait.
127 of the monthly list. So let both the
Wait,
writ petition be
wait,
taken
that
up.
will be heard out analogously. Kindly wait. P4, page 61.
Yes, who is appearing for the state? Mr. Bandyopadhyay. The petitioner claims to
petition copy.
This is my affidavit of service.
Yes.
But my land was not acquired, my lord, under Act 1 for a certain scheme. I received, my lord, the award on, my lord, 2 dates, my lord, I will trouble your lordship. I received the award on protest on 8th of December 1998. My application
8th of December
8th of December, my lord, it's admitted position.
1998.
8th of December 1998, I received
Payment note 12
I received the award on protest, not 12.
award on protest.
Award on protest.
Yes.
Now, my lord, according to me, this date is not admitted. The second date which I am suggesting, according to me, my lord, I filed, my lord, the section 18 application before the, my lord, collector on 23rd of December 1998.
Section 18.
Section 18. May I take your lordship
Yes. Now what happened?
Lord, may I take your lordship?
What is the date of the award?
Date of the award, my lord, is
12/2 notice. When you have received?
My lord, 12/2 notice, my lord, it's sometime in the month of November, according to, my lord, the collector itself.
November
Yes.
2018.
2018. No, 1998, sorry.
November 1998, 12/2.
12/2. And I received, my lord, the award money on protest on 8th of December.
Any decision taken?
Yes. Decision taken prior
Rejected.
to that. Rejected on the ground that, my lord, kindly takes up once, my lord, page 16.
Yes.
As your lordship got, my lord, page 16, my lord, kindly takes up the left-hand line, my lord, top. 23rd December 1998, the received copy, my lord, has your lordship got it?
Yes.
So this is, my lord, which is in my hand, the received copy. This was kept pending. I, my lord, filed a writ petition. Your lordship's coordinate bench directed why you are keeping it pending. Decide the point of limitation. If it is within the point of limitation, forward it to the LA judge. That was the order passed, my lord. I will not just, my lord, page 20 is the order.
Yes. Then what happened?
Then, my lord, the impugned order before your lordship, the LA collector initially said, yes, as per the document produced by me, it is within time. But he seek for a verification whether they are receiving registrar, which their office used to be maintained, what is the exact date on which they have, my lord, make their entry in their register.
What is the impugned order, Mr.
My lord,
Mukherjee?
impugned order starts with, my lord, page 23. But, my lord,
Effective order is page 26.
page 26, my lord, effective order.
Yes.
So, my lord, according, my lord, I have a twofold submission. First, my lord, it is for me, my lord, I have submitted, my lord, one, my lord, protest, my lord, not protest, section 18 application. Your office has given a seal stamp and date. You are not disputing that. What is your official necessity with regard to the making entry of your docket register, my lord? I am not, my lord, looking into of that affairs of that office. You may have made that entry, my lord, sometime in the month of March of the next year. But initial, my lord, submission of section 18 application by receiving a copy by your office, that has not been denied. My lord, that do not obliterate, my lord, my right, my lord, to make the reference, my lord, within time as per, my lord, the second proviso of section 18. And, my lord, the secondly, your lordship kindly sees, I have paragraph 5 categorically mentioned that I received the award amount admittedly on 8th of December 1998 on protest. If that be so, your lordship's court's judgment is now there that, my lord, if it is on protest, that will also suffice, my lord, section 18 criteria. Even the point of limitation relying upon, my lord. May I just indicate, my lord, two of the paragraph for your lordship's, my lord. Paragraph 16 and paragraph 19 of my lord's judgment, my lord, clarified the issue, my lord. Division
I've
bench.
delivered the judgment.
But I'm not carrying, my lord, the other, but my lord, your lordship has already considered, my lord, all the line of judgment. There are twofold submission. If it is beyond limitation, on protest being made, my lord, that will also relying upon, my lord, the one of the judgment of the Madras High Court.
Yes, Mr. Bandhavada, what do you say?
I don't know what is about the Miller, the judgment passed, but delivered by your lordship, my lord. Let me go through
Mr. Mukherjee, do you have a copy of?
a copy দিয়ে দিয়ে দেখে নেবো। And Miller, regarding my lord, page number 16. My lord, learned friend, my just indicates before your lordships, it has been received on 23rd. My lord, the left hand, my lord, on the
December 1998.
8. But from the seal, my lord, it is not appeared, my lord. It is not very clear. The which office is a receipt model or not, but it appears from the record.
Your register.
As your lordship, my lord. As your lordship.
Produce your register.
Yes, my lord.
To show and whether this amount was received on protest.
I don't know, my lord. I have no instruction.
Please take instructions whether this.
Oh, today morning we have received the bill. We have not.
Have you stated that it was received on protest, Mr. Mukherjee?
Yes, my lord, paragraph 5 of my writ petition.
Record produce করতে বলো।
And where is the clear copy, Mr. Mukherjee?
Lord, I don't have 1998. This is, Lord, kindly direct them to produce the original copy which they have received. They are maintaining, Lord, their record. They are saying instead of December, they have received on March, but their original copy is lying with them.
The order of the district magistrate under the heading. Yes. Mr. Bandyopadhyay, please go through that. I have considered both aspects. Payment under received under protest or reference, what is the effect of that? Good. Yes.
And for the petitioner, I'm paying time because
Why?
copy
What
has-
is this matter?
copy service is not yet.
You are appearing for?
I'm a respondent number 2, Union of India.
Yes.
Union of India, item number 6.
6, item number. Oh, sorry.
You are not appearing.
Lords,
I am praying for a time for service the copy.
The learned advocate appearing for the petition.
Item number 7.
Yes.
This is affidavit of service.
State paper করলেন
Initially,
Yes.
the compensation amount has been given at page 21 and I have made
21.
21.
Yes.
I have made a protest, my lord, that measurement was incorrect and subsequently remeasurement was made. And after remeasurement, my lord, the further compensation amount has been fixed.
Yes.
My lord, remeasurement, notice of remeasurement, page 29.
So that has been done. Now the fresh compensation has been awarded.
No, fresh compensation has not been awarded.
Has not been awarded. Where is
That's
the remeasurement was done
Page
on
29.
29. So what is the report after remeasurement?
That is, my lord, page 30.
30.
30. Serial number 31, my lord.
Serial number 31. Jayada Bibi.
My lord, the petitioner.
Now, what is the remarks of remeasurement?
There is no such remarks, my lord, but it was made corrected copy, bottom portion, that is dated 25th April 2024.
No, what is the corrected copy?
And
Whatever, here the measurement has not been mentioned.
no measurement has not been mentioned, not has been intimated to me. That is also my grievance, my lord. Neither
Yes, what is your instruction?
all grievances has been against the respondent number 3, 4, 5, 6.
Who is 3, 4, 5, 6?
Lordship, a special land requisition
Special land
officer.
acquisition officer.
Who is
Superintendent
appearing?
engineer. Lordship, I am appearing on behalf of respondent number 2, your lordship. Union.
State, who is appearing for the state?
No.
So Mahato, you are appearing. Disappear.
Stated কোনো মামলায়
ভালোভাবে সার্ভিস করলেন না তাহলে কি হবে?
সার্ভিস না করলে এফিডেভিট অফ সার্ভিস এমনি দিলাম।
The office of the government pleader.
My lord.
When?
My lord,
Wait to Mr. Mahato.
that is receipt dated এটা কবে কত তারিখ ডেট দিয়েছেন 8th of January 2026.
Long back.
Then,
Sir, copy দিয়ে দেবো।
Mahato, what is happening?
And I shall give a copy to certainly.
2 or 3, 4 hours that is accepted that sometime the GP could not sign on the date. But
It's
this is 8, now we are in
To
15.
be done because there is urgency in the
Urgency in the matter.
You understand the pressure of the
My lord.
Once it's adjourned, it's very difficult to take up that.
Before this honorable court on the date matter is listed.
Yes.
And they are aware of it.
The petitioner alleges instructions if the award has been passed,
On that
modified or not modified, please bring that
on
document.
that very day, I have made a protest, on protest. On that very day.
Yes, next.
But under the same heading, it will appear.
Lord, I beg to appear on behalf of the petitioner.
My Lord, I am appearing for the respondent number 1, 2, and 3, my Lord. I lead
Yes.
Mr. Susuban Sengupta.
My lord, the only grievance is, my lord, the mutation of the petitioner's name is not being done. My lord.
Mutation where?
My lord, mutation with the respondent authorities, my lord, this is a property at Salt Lake. There is a subsisting lease in favor of the father of the petitioners, my lord. My lord, after his expiry, we have applied. My lord, they were not considering. Now, my lord, there is one difficulty. My lord, the predecessor in interest of the petitioners number 6 and 7, my lord, the original death certificate was not made over. My lord, so on the basis of the cremation certificate, which was available, my lord, I had applied. My lord, they have not rejected my prayer, nor have they considered it, which is why, my lord, I am today before your lordship. My lord, my representation.
You have not got the death certificate?
My lord, that has not been given to me. I have made alternative prayers, my lord, for issuance of the death certificate.
Kolkata Municipal Corporation death certificate is issued then and there at the time of cremation.
My lord, the cremation certificate was issued. My lord, thereafter, my lord, we applied. My lord, I have also made a representation to the appropriate authority, my lord, requesting for issuance of the original death certificate, my lord. I'll show it to your lordship, my lord. My lord, the cremation certificate is
not within the Kolkata Municipal Corporation.
That is the problem. In other state, my Lord.
In?
No. My lord, page 59 is the cremation certificate.
The address is Narendra Sen Square, Kolkata, because it's Salt Lake and Bidhannagar Municipal Corporation.
My lord, but cremated at, my lord, Neemtola.
You have to collect the death certificate from Bidhannagar Municipal Corporation. If it is within Kolkata Municipal Corporation, your address is within Kolkata Municipal Corporation, cremation, then and there you will be getting. That is why I was astonished. Kolkata Municipal Corporation gives issues death certificate at the time of cremation. Why would not take a steps for the issuance of the death certificate till
My
then?
lord, I have made, my lord, representations, my lord, that is there at page 86. My lord, this was made to the register Bidhannagar Municipal Corporation.
That's a different thing altogether that does not come within group 1.
Yes,
So you have to text us. Now, what is the difficulty?
my lord, now the difficulty is that on the basis
Where
of,
is your representation?
my lord, page 86 is my representation for issuance of the, my lord, original death certificate.
So that is, you have to approach.
My lord, my request for mutation is at page, my lord, 60, page 60, my lord. This is a letter 60, my lord. This is annexure P10. This is a letter dated 17 September 2025.
Yes, what is the instruction?
No, actually, instruction, I have one ballot is for instruction ballot on 10 days time ballot. Because mandamus is not playing against me, only certiorari playing ballot. So I am playing for instructions ballot for 10 days ballot. 10 days, 14 days.
Mandamus is not issued.
My lord, prayer B.
No, only certiorari ballot.
My lord, my first prayer is
Against
prayer B.
What is prayer B?
My lord, page 17. And my alternative prayer, my lord, is
prayer B, sir.
Commanding this particular 2 and 3 immediately record the name of the immediately record the name of the petitioner mandamus.
So that's not mandamus.
First place,
When you are taking the point of continuity, please go through reliefs and the petition.
Yes, my lord.
Don't merely come and say it's not maintainable.
And instruction is required, my lord. Kindly give me 2 weeks time, my lord.
Dispose of this representation, take a decision. The petitioner.
Item number 9, although I appear on behalf of the respondent number 6, but I have been requested by.
Milord, I appear, Milord,
You are for the
it is
petitioner.
petitioner, আমি respond.
Yes, yes.
Milord, the learned advocate for the petitioner, Milord, has suffered a bereavement in his family, Milord. I've been requested to kindly ask
He
for
also
not this week.
requested me also to pray for this week. His mother-in-law expired today morning.
All right, so you have got your instructions.
Yes, I have got instruction.
See the case, my lord, that only the lease was executed in March 2020, January 2021, but registered on March 2021. So the period is subsisting maximum to 15th March 2026.
His lease is still valid.
What they are paying?
Not paying, they are paying for challan for entire year. It cannot be. Only 2 months left. He can pay for only on entire
Because his lease is subsisting till date, he will be allowed to excavate sand as per the environment clearance quantity, because he cannot excavate according to his wisdom. There is a prohibition in the environment
Under
clearance.
this period, he cannot do that.
Yes.
Yes. Only two.
Prasim, kindly keep this matter on Monday.
Milord, 1 week's time, Milord, kindly.
Uh,
Anytime next week, Milord.
An accommodation has been sought for on yes.
And this is my affidavit of service.
Yes.
But I have received a letter from my client that he wants to withdraw the petition with the liberty to file afresh.
Why? What are the technical defects?
No, my lord, one of the respondents has called them, not through any official letter, but they are trying to resolve the issue. So
They are trying to resolve the issue.
But I appear for the private respondents. The officers in the personal capacity has been implemented as
Third
respondents.
The OSD.
Some allegations
Well,
against
the
that.
allegations are vague. Vague allegations. Well,
Now, she wants to withdraw this.
respondent numbers 5, 6, and 9.
The district magistrate has been by name particular.
this is the letter.
4.
The learned advocate appearing
And this is my affidavit of service, and this is the letter of the.
next same. You are appearing.
Appearing.
Same order next.
Next is also same.
12 is also same.
12 is also same. 12 same order next.
Grateful. Grateful mill. 10, 11, 12.
Yes, next.
Nama in all the 3 matters. Eta niye na.
এখন এখানে দেয় না বলে।
Please file it in the department. It will be getting a number. Yes.
We'll file it.
এখন অনলাইন এখানে।
Item number 13.
Yes. You are appearing, Mr. Dotto. 13 দেখি।
Item number 13.
Lordship, Shami Mulbari is appearing in this matter, Lordship, praying for a short pass over,
You are
Lordship.
here. Yes. Who is for the state? Yes. What is this matter?
Lordship, I am not well aware. I don't even have the file, Lordship. Kindly grant a short pass over, Lordship. He's engaged in courtroom number 18.
I can give short passover, but you have to argue. Please take the brief. Short passover, I will not allow Mr. Shamimul Bari to argue. File ta din onake. You have the brief with you.
Lordship, it's there in the next court, Lordship.
All right. Passover at 12.
Lordship.
Yes.
Item number 14.
Yes.
No,
Yes,
the
Mr. Rao.
petitioner is the owner of the land measuring about 5 decimal in respect of plot number 209. Besides the land of the petitioner, there is a PWD road. Now, my lord, the private respondents, what they have done, they have encroached the PWD land by the side of the road land, and I made an application before the executive engineer and assistant engineer. Say, look, this is going on. Now they have temporary construction has been made, but section 10 proceeding has not been initiated. Now, only I am making a prayer. You lordship kindly give a direction to the executive engineer.
Private respondents have been served. Who is appearing for the state?
My sir.
You are for the state.
My lord.
Yes. What is your instruction?
My lord. That petitioner representative has been sent to the concerned BLRO for the
Demarcation.
for demarcation.
What happened thereafter?
So far, not no reply has been obtained from them. After filing the petition also, yesterday it has been once more sent.
Why BLROs are nowadays very busy? Mr. De?
All the BLROs and revenue office.
No, not for SIR. Prior to SIR also. Prior to SIR also.
Nowadays, they have
Prior to, so it seems that the BLROs are very busy.
as because my lord nowadays my lord when the registration is made my lord that file is my lord transferred to the BLR office to mutate the name my lord. For that is my lord there is some and other things my lord because they are
The petitioner claims to be
Lord, in 15, my lord, I am appearing for the petition, my lord.
And for the state, my lord, I have not received any instruction as yet. I have received the brief today in the morning. Only the police report has come.
This matter is similar matter like the previous one, my lord. The grievance of the petitioner is that the private respondent, my lord, illegally and forcefully encroached the land measuring about 14 decimal belong to the Public Works Department, my lord, which has been acquired long back in 1946 by the KZ notification. And that land
Acquired?
Yes.
Acquired for PWD?
Yes.
Roads?
And yes, my lord.
So now there's an encroachment about PWD roads?
Yes, my lord. The encroachment has been made at the instance of the private respondents, and thereby, my lord, also encroached the ingress and egress of the petitioners, my lord. And if your
You have
lordship,
not addressed a representation to the appropriate authority.
yes, my lord, it has been sent to the. If your lordship kindly,
whom?
If your lordship kindly come at page number 23 first, it has been first sent to the concerned BL and LRO.
Block land and is not the appropriate authority
And
under the
thereafter-
Highways Act. It's the
Yes.
assistant engineer. You have not addressed a letter
Yes.
to the assistant
Lastly,
engineer.
my last representation has also been sent to the concerned authorities. Only if your lordship kindly
Not
come
the
at-
assistant engineer. Assistant engineer is the appropriate authority, sir.
Yes.
I give you liberty to make a representation to the
Great, my lord.
the petitioner claims to be the owner of next.
Affidavit of service, my lord, may be kept on.
Fine. Yes, next.
Lordship, in item number 16, I am on behalf of the state, Lordship.
Yes, yes.
Lord. Lord. Acquisition of land by the,
Yes.
by the concern of PWD, Lord.
You are for the state, yes.
Lordship.
Book payment.
Lordship, on the earlier date, Lordship asked the state that Lordship instructed us that to take the instruction from the state what is the actual quantum of the compensation, Lordship. So, Lordship, on the basis of this Lordship's direction, I personally talked to the respondent number 5. And Lordship, respondent number 5 informed me that he will be present physically
tomorrow for the purpose of the clarification of this, because actually regarding the quantum of compensation, the respondent number 5 is not able to say. The quantum of the compensation will be said by the secretary. So for that reason, already the file has been moved, and Lordship,
Where's the report?
Report, my lord. Report has been filed, my lord.
Yes. Report you have filed.
My lord.
Now what
Yes,
more do you want? Yes, what is your submission? Please make your submission. Yes, report has been filed. Yes.
Yes, Lordship, report has been filed, but actually in this the report it is stated that the previous as per the previous act, we are the compensation will be given, but Lordship asked us to take the instruction from the state what is the actual amount of the compensation, what should be. So regarding the purpose of the taking this instruction, Lordship,
Where is Mr. Dor?
Lordship,
Yes, madam. Where is Mr. Dor?
Lordship, he's in tribunal. Yes, come.
He is a regular visitor in the tribunal nowadays. That cannot be a ground for adjourning a matter before the High Court. Yes. PM, ask him to come at 2 PM.
I permit to next matter, my
Malad, kindly hear me, Malad.
regarding
Yes, Mr. Dor. Yes.
Yes, Malad, I tried to get the information from my client, Malad. I was unsuccessful, Malad. Malad, at 2 PM, Malad, I won't be able to assist, my lord.
What instructions you sought from your client? What
Zero.
instructions?
I would say zero.
No, what instructions you sought?
Malad, that
Not
my
what you sought.
my learned friend appearing for the writ petitioner has said on the last occasion that his demand is, his client is looking for 38 lakhs, if I'm not wrong. Is it?
Lord, 2 lakhs, at least 2 lakhs per decimal. At least 2 lakhs per decimal.
Yes, how many decimals?
29 decimals, 29 decimals.
29
So that's
decimals, 2 lakhs per decimal.
Oh,
He said 2 lakhs per
60.
decimal.
Then it's almost 58 lakhs, if
58
I'm not
lakhs,
wrong.
yes.
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 Then, Malad, thereafter, I asked my learned junior to catch hold of my client and then ask them to. Then initially, the response which I got that it would take some time because we need to send it before the land purchase policy department. So,
or if he is not willing, then you cannot send it. Even if it does not help.
Malad, let us come back. If it no, Mr. Last occasion, he said that he is willing if he gets about 58 lakhs, more or less.
But now you have to send to the direct purchase policy, that committee that will decide, that will take time. So let us proceed in accordance with law. What will be the law? Please take steps in accordance with law, because that will take time. And it was adjourned from time to time. You could not even come with a proposal. He has given his proposal. You cannot straight away come to a decision whether to accept it or not, because he's the seller. He's quoting a price. So sending to a committee, taking decision
with 2 sale bids I have given.
That might be
not committee. I'm submitting, my lord, this particular amount should be approved by the higher officials. No, that's why my client wants to say that they are not in a position at this moment to say yes or no. They have to send it before the higher authority who can give the approval. So kindly give us a 1 week's time so that I can do this exercise.
Mr. Thor, file a report with regard to that. That his proposal you are sending. Please file a report to that effect. Nothing on air. Everything now, everything you are saying that they will, what
Yes,
price?
yes, I can. No.
It on a report that this is his price. So you are considering that price. For that you are sending to the committee. Nothing, everything on vague. Yes, we are saying that. Then he will say, no, we are considering 1,000 per decimal. He is claiming 2 lakhs. So something has to come in writing. Someone has to take a responsibility that you are forwarding that proposal to that authority.
Well, we'll come back with the report then.
Yes, day after tomorrow, Monday.
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 Lordship,
Yes, Mr.
Lordship, kindly,
Many adjournments have been given.
Lordship, kindly fix it
Many
Tuesday, Lordship.
exceptions have been given for the
No,
filing.
it's from Midnapur, I believe.
Yes,
If I'm-
Midnapur. I think
Paschim Midnapur.
yes, from Thursday to Monday, persons cannot come, Mr. Dor. From Paschim Medinipur, how far it is?
It's not a person coming and going. As also the person has to be addendum with us. That is the difficulty.
The difficulty, that's your job, Mr. Dor. So
yes,
Thursday to Monday is sufficient time for coming from Paschim Medinipur to Kolkata.
Well, I beseech my lord, kindly keep it on Tuesday. Kindly
Tuesday,
give us
Lordship,
one
kindly
day.
Tuesday, Lordship.
Thank you.
I am claiming on this report.
So
Lord,
please file a
please.
report as a last chance. Otherwise, I will proceed on the basis or report you have filed.
Yes.
In form of
File a supplementary evidence then. Supplementary report then.
Yes. If
on the
my
basis-
client is not agreeing with the price he has quoted, then my lord will proceed.
I have relying on the Lord deeds. I have relying on the deeds. We have annexed to the writ petition.
Mr. Dhol, a senior advocate appearing for Yes. What is the next matter?
Same, my lord.
Next is same order.
Lord, I have.
So you also
I have
file a
used only exception, my lord.
supplementary report.
Lord, I have used only exception, my lord. Exception, my lord. In the previous matter, I have given
Exceptions to the earlier report.
I have, my lord.
Exceptions to the earlier report. Exceptions. Next matter. Exceptions to.
Lordship, I am for the petitioner, Lordship.
Yes.
Lordship, in this matter, Lordship, on the last occasion was pleased to pass solemn order by directing the respondent authority to submit the report. Yesterday, Lordship, this report has only, Lordship, written affirmation has been served without giving any documents, Lordship. Property has been utilized by giving compensation and assured by the authority, but they did not give. Now,
Yes. What is the supporting document in respect of your statement in paragraph 4?
My lord, actually, my lord, your lordship, verbal, as per verbal assurance, my lord, the pump was set up.
Verbal assurance donation
Donation.
of
Although,
a immovable property.
No, it cannot be possible. I know it, my lord, 123 of the Transfer of Property Act. But
The
my lord,
executive engineer is taking this stand, filing a report.
filing a report. And my lord, actually, my lord, the PAM has been set up as per his verbal request.
Yes.
And to also, my lord, to
remove that. Please remove that.
Then, my lord, your lordship kindly, my lord, direct the my lord, concerned authority consider the representation and pass.
But no representation, sir, now. Either acquire or remove. Choice is yours.
my lord, as per my lord, his request also, my lord, he has been engaged as the my lord, pump operator.
Show me. And you are acting on the verbal statements. You are utilizing the plots nowadays. Donations and immovable property. You become the owner. And this is the stand of the executive engineer.
10 years already, my lord, it has been utilized by the government. Already 10 years have passed, my lord. This has been utilized by the government.
Pay damages for these 10 years. Pay damages for these 10 years.
And also, he requested us, my lord, to engage him as the pump operator. He has been engaged as the pump operator in the said pump. And source of
Show me
living.
that was the condition. That since he has been
No
engaged,
condition,
he will
no,
not.
no
He has
condition.
foregone his right of
No
compensation.
condition, no condition was there. He did
So-
not impose any condition at the time of Mama offering the land. Accordingly, even he did not raise any objection also.
Nowadays, you are taking an immovable property on verbal assurance.
That is the main problem.
And this is the stand of an executive engineer.
Then regarding my lord, documentary evidence, I also requested them to give me some papers. My lord, at present, my lord, it is not available. So your lordship already report has been filed.
Asun.
So
The petitioner alleges that yes, I'm coming after 5 minutes. Call that. Yes.
13 রেখেছে?
Lordship,
Yes, who is for the state? Who is for the state? Have you served upon the state?
Lordship, affidavit of service.
Yes.
Lordship, I have to ascertain that who is for the state. I have to ascertain that who is for the state.
Who is for the state? All right. What is the matter?
Lordship, the petitioner herein is the predecessor in interest in 1964-1965 Department of Irrigation, Government of West Bengal acquired a 1 decimal of the petitioner's land verbally, taking the verbal consent of the predecessor in interest to install a deep tube well, and it was verbally agreed by the predecessors in interest of the petitioners herein. Then but they verbally promised the petitioners to give some utilization charge, but that was not paid to the petitioners. In 2023, the Department of Irrigation tried to change the classification of the entire 12 decimal of the petitioner's land from Shali to the deep tube oil. Through the RTI, there was a RTI made by the petitioners in annexure page 25, Lordship.
Yes.
They replied that there is no correction done.
Yes.
Then in 2012, subsequently in 2024, the department again started trying to construct by encroaching the entire 12 decimal of the petitioner's land, Lordship. In 2020, in 1st April 2024, petitioners made written complaint to the competent authorities. That is in page 26, Lordship. Of the writ
26,
petition.
yes.
Thereafter, thereafter they didn't pay any heed, and they continued to do the construction therein. In 2024, June 2024,
Yes.
the petitioners filed a writ application here in honorable court, and the court directed the state respondents to consider and pass a reasoned order.
Yes. Now what has been done?
They till then they didn't pass any reasoned order.
Now the reasoned order has been passed.
Yes, Lordship.
Now you are challenging that reasoned order.
Lordship, the reasoned order is in page 35.
Yes. On what ground? What is the infirmity in this?
Lordship, in 36, page number 36.
Yes.
That they said that the undersigned concludes that this belated stale claim after a passage of more than 61 years is not legally tenable.
What is the wrong in this? After 61 years, you have approved.
Lordship, this is my land. Kindly let the respondent authority give some document regarding that land is acquired by them. Any proof of the...
Yes. Who is appearing? Nobody is appearing. Yes, Mr. Banerjee. Fine. Please take instructions. Actually, heard the learned, heard Mr. Bari. Assisted, what is your name?
Ashmita Mitra.
Assisted by such and such. Yes.
Dada. On 2nd January,
The Banerjee, you have to file a report. Have you served a copy?
No, my lord.
Give a copy to Mr. Pan.
পড়ো না তোমার সব আমাদের
Lord, basically, report is that, my lord, it's a very old case, my lord. There is no record of, my lord, transmitting the money to the, my lord, acquiring body.
So what is this matter? What is this matter?
No, my lord, the property was requisition under Act 2 on 1948, followed by acquisition.
Followed by 41A.
41A. Therefore, nothing. Now, my lord, in the similar type of cases, in the some proceeding, acquisition proceeding, 2 orders were filed by the other coordinate bench. My clients were agreed to the direct purchase policy. Here also I am agreed to the direct purchase policy. If they want to contest this thing, my lord, here and now I can argue.
No, direct purchase policy.
Yes.
Now the
So
direct purchase policy, Mr. Banerjee, what is your report? What does the report say?
Nothing.
Direct purchase policy, you have to give a proposal.
This proposal was not given by Mr. Pan on the last day. My report is not.
No. All along I am
Proposal.
submitting.
Why he will give?
Yes.
You have to offer. He will accept. He says if you go for direct purchase, he can accept that. Proposal cannot come from him.
Proposal has to come from the requiring body.
Yes. Because he wants 2013 Act.
Yes.
My lord. And possibly they should not accept this proposal, my lord, and that is not better for everybody. So, but this
proposal, you are not coming forward with any proposal. Yes, Mr. De, what is your instruction?
My instruction is nothing, my lord. I first filed this application, my lord. I have said 41 is there, 41A is there. After that, nothing. So, my lord, we are ready
Direct
to
purchase policy. What is your instructions on that?
nothing on that point, my lord. He is the requiring body. Only for that reason, on that day, my lord,
Banerjee, you have to forward a proposal. Or if you don't want direct purchase policy, then in terms of law, it is to be 2013 Act. You have to.
I'll take specific instruction on this. I'll advise them, my lord, because
what is this report? What is this
says,
report?
my lord, that the acquisition
May I say,
lands are not available.
Sir, kindly turn to the last page of the report. My lord, If report. that be the stand, my lord,
No, my lord.
No, my lord. Allow me to argue.
My lord, your lordship will not go through the report. That is a very bad report.
Yes.
Told,
So if you say like this, then
yes,
I can
my lord.
understand the matter.
No. I told
And
my
the report has been
learned
filed
friend,
by
my
the
lord.
senior superintending engineer.
তুমি আগে দিন এটা স্পেসিফিক্যালি বলে দিতাম এটা ইনস্ট্রাকশন নিয়ে আসবে whether they're agreeable for direct
থেকে বলে আসছি তো। প্রথম দিন থেকে বলে আসছি।
I'll take
Only
instruction
for
specifically on that.
my lord, we are not.
I shall take instruction specifically on that, my lord, regarding direct purchase.
But your instruction is that convincing documents are to be supplied from the end of the collector. He has blamed you, Mr. De.
Whatever may blame my lord in my report. My lord, last part is there, my lord. My lord.
Yes, Mr. Banerjee.
So, my lord,
On this specific issue, my lord, I'll take instruction. Kindly allow me 7 days time.
You want to file this report or you want to file another?
No, my lord, that report.
I'll withdraw that, my lord.
I do not want to file that report.
Mr. Banerjee.
My lord, I am appearing on behalf of state.
20, my lord, I am from the petitioner.
My lord, I am praying accommodation for next 7 days, my lord, to file the affidavit, my lord.
But kindly remember, my lord, this is a matter, my lord, where my land is being, my lord, utilized in respect of the same LA case, wherein, my lord, the other order is being passed by the coordinate bench.
Sorry.
Yes, what is your instruction?
My lord, I have to file the affidavit. Allow me 1 week time.
So it was given on 5th till 14th. This time was given.
This affidavit was called for by your lordship
Specific 2 points.
since in one of the coordinate bench matter, there are the plots involved is being mentioned, but these two
Documents are there in the writ petition. You have to only confirm whether his plots are subject matter of those or not.
7 days
But
more
bloody
time.
one of
my
the
lord, I will
matter,
file it. My lord.
On the prayer of the learned
Both methods are the same, lordship. Same matter. I'm praying for the same.
Same order. Next. Yes.
Your lordship directed that this.
Yes, where is Mr. Banerjee? All matters are yours, Mr. Banerjee. Why are you leaving court? All the matters in
Pan
case
was
are
not
yours.
taking me to task for filing the report in the previous matter.
Yes. You have got the report.
I have received the instruction that they have passed an order already. 21st April, a date was fixed.
Yes.
On that day, my senior friend he says that he could not
Oh,
appear
this
on
is that he wanted another opportunity.
appeal under section rule 51. He says that no hearing was not fixed.
He said due to technical fault he could not join.
appear, but order has been passed already on that date.
On which date?
21st of April.
Nothing.
Then you have to challenge that because order has been passed. Sir, if an order has been passed, unless you challenge.
My lord, let Gilbert be given to file a supplementary affidavit.
Please,
How it
please
has been
give the order, Mr. Banerjee. Where is that order?
My lord, I have filed a writ
And
application.
it says, my lord, that they were represented.
After thought. Completely after thought.
They were represented.
How the copy has been served to us? No copy has been yet been received. It was completely stopped. Completely an expiry order. How is it?
No, not expertly.
আমার hearing হলো না অনলাইনে বন্ধ হয়ে গেল due to fault of this. How it has been order has been passed without hearing me?
Mr. Banerjee, did you communicate this order?
No. How it has been communicated to me?
Why post করতে হবে? No. I don't have. I only
2025 till this date you have not communicated this order.
Yeah.
Why? What for?
I'm told that is verbal instruction that they have
I'm
not.
asking you.
Verbal
This
instruction
order
is
was
that
not
they have not
communicated.
accepted service of the copy by hand, so it was pasted in their house. But that is a belated. What I find out the pasting was done belatedly, my lord. Not at that point.
Pasting was done.
In January, so not at that point.
What is the date of January?
14 January. 14 January.
So
After
immediately after the order was passed.
Yes.
my lord.
It completely after thought. How is it possible?
No, but তোমায় কবে কমিউনিকেট করেছে হোয়াটসঅ্যাপে অর্ডারটা?
They neither hear me, nothing else.
On the previous day, upon communication, immediately, the order sheet was sent to my landed junior through WhatsApp. The order sheet was there. Communication was not there. When the matter was called on from the first day, I sought for time.
When this
I sought for time, and immediately my junior contacted the department. They have sent the order sheet immediately. They could not have prepared the order sheet by immediately and sent it, but communication was not there. I don't find any contemporaneous communication.
communication was not there, no effect was given, please reconsider.
If the order is signed, my lord, by the authority, my lord,
You
if
have
it
to
is
reconsider that because you have not communicated that. It's an appellable order.
in appealable order, in appeal, my lord, this has been
This is
passed.
the order passed by the appellate authority.
Appellate authority. That is the order, my lord. Appellate
Yes.
authority. So, my lord,
So
they
if
will
you
have
have
to
not
challenge.
communicated, you have to reconsider this. And when they said that they could not join due to
But
link
the order
failure.
sheet, my lord, records not that the appellant is present through counsel.
He
Kindly see.
joined, Mr. Banerjee,
No,
he
the
joined.
senior might I don't, then kindly allow me to file a report on affidavit because, my lord, your lordship will say this, I can't take it on me because it's records that the counsel was present. The learned senior was from here appearing virtually, but somebody was there.
The junior was there, physically
Name is there.
Well, yes,
So it was hard.
he was also present with me.
He was hard.
No, I started.
Please see the order.
Yes, my lord.
Mr. Banerjee, please give a copy of this.
Thereafter, I tried this.
Maybe he was, somebody was there.
Somebody was there.
Learned advocate of behalf of Somnath Chatterjee. Somnath
Somnath
Chatterjee
Chatterjee
was
is my client. He's a client. He's my client,
Somnath
man.
advocate is, on behalf of the appellant.
I was present and my junior was also. The link failure was had.
Thereafter,
It was stopped.
several times I tried.
Anyway, it's a fact.
Mr. Banerjee,
Let them file an affidavit, my lord. Let the authority
file an
file
affidavit as to whether any person
was present.
who was heard on that date, because
Whether the
specific
hearing was
statement
completed.
that due to link failure they could not join.
Yes.
Whom have you heard?
Who are allow me to file a report because on affidavit because they have to, my lord, take the responsibility.
Yes. Mr. Banerjee, learned advocate.
decide whether the order is good or bad. So,
It will be open to the petition.
uh, 2 weeks.
Which
of the time?
can we fix the date?
4th February.
My lord. Point
4th February under the same heading.
My lord.
Yes, next.
23, my lord, I am for the petition.
Yes.
My lord, this is the acquired land of the government, but the name has not been corrected. That is the fact. My lord, I have given the sketch map, which portion has been acquired, and the report discloses that
How many?
No, it's it's a acquired land.
Acquired land.
No,
Compensation paid.
Everything. Acquired everything.
Nothing, my lord. My lord, kindly see the record of rights.
Record of rights is
When it was acquired.
that-
And how many area acquired?
everything
Total-
is given.
Total area, kindly
He's
give me a
filing a report.
Yes,
Report
yes.
states everything.
Yes.
Only
report
saying
report
everything.
says everything.
Give me a report.
Yes.
Please give a copy to him.
Yes, I have already given.
Have you given a copy, Mr. Mahato, to him?
Yes.
Yes, miss. Just now, yes, given.
Yes. When do you want?
Within a week.
Within 1 week. All right. Pursuant to the
I'm appealing for the petition.
yes.
But, before my learned friend starts, my lord, I, my lord, have some pages of the writ petitions are absolutely illegible. My lord, what has been circulated. My lord, besides that, my lord, the matter, my lord, even while the point of maintainability is there, my lord, perhaps this should go before the learned LRTT. My lord, this relates to, my lord, long-term settlement of lease, my lord. This is under section Rule 20, capital A of the Land Reform Rules. And my lord, there being a matter of specified act, my lord, this
Land
should perhaps
reforms rules or land reforms manual?
rules, my lord, 20, capital A.
Now, Lordship, this is not under Lordship
So,
section
my lord,
49. The
irrespective
settlement
of,
is
my lord,
not
good,
done,
bad,
Lordship.
indifferent, my lord, my respectful submission
Kindly
is, my lord,
consider Lordship page 21, the issuing authority, Lordship.
this is a
The
question of
renewal authority.
maintenance.
Page 21, Lordship, the first renewal granted in favor of the petitioner for 30 years under 219, Lordship. The issuing authority, Lordship, is the Assistant
Yes,
Secretary.
yes.
Assistant Secretary.
West Bengal Land Reforms Manual.
Yes, my lord. Ransom 217 onwards, chapter 15 kindly sees. Also, my lord, read with, my lord, Rule 20, capital A of the Land Reforms Rules.
No, this was issued in terms of Land Reforms Manual, not rules.
My lord, this is, my lord, 20, capital A, my lord, terms and manner of settlement of land at the disposal of the state government under section
Please
49.
kindly come to 21.
Yes, my
It
lord.
does not mention that rules. That is in terms of section 49, that settlement.
49,
My lord.
Land Reforms Manual. And there is the division bench judgment, which says writ petition is maintainable.
My lord, I just, my lord, need certain pages from him. I'll indicate the name, numbers of the pages. I think 19, 20, my lord, these are completely illegible. My lord, the copy that I have, my lord, I can hand it up. Right.
Arnal, why are you giving?
No,
So, my lord, I'll come
But
back with
I
instructions.
don't think he can give a better copy.
19 and 20, Lordship,
And my lord,
20
page 16.
It's not that there is not.
19 is legible.
No, not 19, my lord. I stand corrected. It is 16.
It is the map.
20 is the map.
It is appended
This
with
prayer
the
is
page.
only for
Few pages, my lord,
They
which
have
are
already
page. Which
20,
page?
my lord. 20, my lord. This is the page.
20 is the map that is
Yes.
also in my page.
And my lord, 16 and 17, my lord.
16 and 17. Yes, which
I
portion
do
you
not know,
cannot
my lord.
read?
The
Which
first
you
portion,
cannot
my lord,
read?
the indenture portion, my lord, it is illegible.
Indenture.
Yes, my lord. Perhaps your lordship's copy may be better copy. His copy is far better than mine.
Please give me your copy.
Yes, my lord.
Let me see whether.
And my lord, kindly sees his copy, which he is using.
The name of the petitioner is appearing their lordship and the date of the execution.
তুমি আমাকে একটা ভালো কপি দাও, আমি দেখে নিচ্ছি যদি করা থাকে। কালকে দাও।
Pursuant to my representation, they have already asked from the lordship BLR for assessment of the land. They should complete the proceedings because under
Yes,
219,
Mr. Dotto.
under 219, I am entitled to lordship renewal unless the condition of the deed is lordship violated.
What is the decision after this?
Nothing, lordship. There are representation after representation.
My lord, that, my lord, I need to take instruction. I have just
That
been.
you have to take instructions.
Yes, I have to, my lord. I have no
That
other.
you have to take instructions without going to those objections as to the
Lord,
mentality and other things.
Yes.
This is the thing. You have taken a decision with regard to the renewal. Additional district master has written to the block land.
But in 2023, there is the
Filing report.
Detailed status report along with a sketch map, valuation regarding long-term settlement. What has been done?
Yes.
Thereafter, the representations have been made. And this was in terms of the land reforms manual.
29.
There's a division bench judgment which says it is maintainable, Mr. Dotto. Are you aware of that decision?
But I'll find out. I'll find out and come.
Where is that decision?
Your lordship is saying about Abdul.
Your senior argued.
I will lordship bring. If your lordship, I will lordship bring.
নামটা বললেন?
I'm not carrying this lordship, but if your lordship did, I will place the judgment.
My lord keeps it someday in the next week. I'll come back with this.
There's also a contrary judgment.
My lord, there is always a contrary judgment, my lord.
That's
Most
in your
grateful.
favor. But the earlier judgment was not considered there.
Very well. Oh.
Earlier
Very
judgment is against you.
Very well.
Hmm.
Your Lord.
Kindly fix it.
No, no, no. One
Forward.
chance
Kindly,
given.
kindly take it as forward.
Yes, yes, call the next matter. Yes. Wait.
I am for the state. Manual, whether it comes within ambit of the act and specify it. There are two judgments I pointed out to your lordship that the two judgments, not one of Justice Mukherjee and a subsequent judgment, my lord. Your lordship wanted me to bring both the judgments and I have brought them, my lord. And before that, I just want
The subsequent judgment took into consideration the earlier.
held the earlier one to be par incuriam. Held the earlier judgment to be par incuriam.
Where is that? My lord, one judgment, my lord, by Subrokamal Mukherjee, another, my lord, latest judgment, Justice
No,
Raja Sekhar.
Justice Orijit Banerjee.
Whether
And
this
Justice
judgment
Apurva
has been-
Sinha Ray. কোনটা আগে? ও আরো একটা আছে?
Yes.
First is না. I'll give the dates, my lord.
Probably.
23rd December 2013 is the judgment by Honorable Justice Mukherjee.
Yes.
And my lord, the judgment 21st May 2024 is the judgment by Honorable Justice Orijit Banerjee.
Yes.
And my lord is referring to some other judgment of Justice Mantha.
Mantha,
The
yes.
Date কবে?
এটা হচ্ছে ডেটটা হচ্ছে
That is
15 July 2025.
25.
25.
So, my lord, first
And-
judgment is by Justice Mukherjee, which says that Land Reforms Manual is not part of the Land Reforms Act. Subsequent judgment, my lord, holds not the previous judgment to be par incuriam. Now, whether this judgment has been held, considered in the judgment of Justice Mantha, we have to see, because if this is not considered by Justice Mantha, then my lord, the previous one will prevail. 24th judgment will prevail. Because section 52 has been considered in distribution of land and rule 28B, those two provisions are not considered by the previous judgment.
No, no,
So
Your
rules
Lordship
are-
kindly, my lord, Your Lordship knows the judgment of Justice Mukherjee, my lord. Your Lordship,
I do not know anything.
No, no.
What you are telling, I'm only hearing.
আচ্ছা, একটু বলে নিয়ে
আপনি বলেন।
First, Your Lordship kindly see the judgment of Justice Mukherjee. My lord, it deals with the manual. Now, you concluding part, Your Lordship kindly come. Paragraph 14, 15, 16 and 17. My lord, it has been said
Please give me a minute. Please.
that 17, yes, detailed discussion is there. Similar point was raised.
ওখানে একটা জাজমেন্ট পড়ছে, দেখে নিতে দিন ওটা। আপনি তো ওটা এনেছেন কি অরিজিৎ ব্যানার্জি হিসেবে জাজমেন্টটা? ওটাই তো আসল।
ডিভিশন বেঞ্চ তো
ওটা আগে প্রেস করতে হবে, তারপর মান্তা সাহেবেরটা। মান্তা সাহেবের জাজমেন্ট স্যার, এটা রেফারেন্সটা দেবেন?
এটা কি এটা?
হ্যাঁ হ্যাঁ, মান্তা সাহেবের জাজমেন্টের রেফারেন্সটা একটু দেবেন স্যার? কপি
হ্যাঁ,
আছে?
নিয়ে নাও।
কপি আছে?
কপি নেই, লিখে নাও।
কলমদা কপি দাও না। দাও কপি দাও।
আর দুটো আছে কপি, একটা জোসেফকে দিলাম। আচ্ছা, লিখে নাও, লিখে নাও। এমএটি 139।
বার করতে এক সেকেন্ড স্যার।
And what did the subsequent, this is the subsequent judgment of 16th of July.
Yes.
এটা কত?
16th of July, what does it say?
Yes.
Does it take into consideration the earlier judgments?
Yes, yes, my lord, everything, Your Lordship kindly come.
স্যার এমএটি নাম্বারটা একটু দেবেন?
এমএটি হচ্ছে 139/2025.
139
Your Lordship kindly come.
20.
My lord, paragraph 22 to onwards, 24, Your Lordship kindly see.
না এটা করে
Equal the stand. Paragraph 24, Your Lordship kindly see. The stand of the government that the manual has got no statutory force. Your Lordship kindly see. Paragraph 20, 23 and 24.
জাস্টিস ব্যানার্জির জাজমেন্টটা কনসিডার করেছে কি?
Justice.
অরিজিৎ ব্যানার্জির জাজমেন্ট নালে তো হবে না।
মানে সেটাও তো ডিভিশন বেঞ্চ।
কোনটা? এটা?
হ্যাঁ।
নট কনসিডারিং দ্য প্রিভিয়াস জাজমেন্ট।
লেটেস্ট
পার ইনক্রিয়াম হোল্ড করে দিয়েছে। ডিফারেন্স অফ ওপিনিয়ন নেই তো। ডিফারেন্স অফ ওপিনিয়ন নেই, বলেছে যে আগে জাস্টিস মুখার্জির জাজমেন্টটা
হ্যাঁ
দুটো প্রভিশন কনসিডার করেনি। সেকশন 52 আর রুল 28।
But Mr. Banerjee, the earlier judgment has been accepted by the subsequent bench.
Subsequent bench. But my lord, without considering that in the second judgment, my lord, the previous judgment has already been, my lord, held to be par incuriam. There's finding, my lord.
I think
That
it's to be
two provisions have not been
to be referred. Because which judgment shall hold the field?
Later.
There are two
I find,
conflicting,
my lord,
there are two conflicting division bench because the earlier has been approved by the subsequent one.
without considering, my lord, the
So
and
let
Lord,
the
kindly
division
consider,
bench
my lord,
say, or the larger bench say which one.
before going to that, my lord, kindly consider section 52 is not management of land. 52 deals with any land under the disposal of the state government, it can be distributed. And their representation is specifically that the land at the disposal of the state government can be distributed, but this land.
No, that is not the correct one. Our case
that
is, no, that is not
it
the
has
case.
been leased out by treating it to be a land under disposal of the state
Yes.
government.
It cannot be done because
So whether it is a land at the disposal of the state government under 52 or not, that question has to be considered in this matter.
that has been considered by the
Whether it
tribunal.
is correctly done or not.
Tribunal has decided the issue.
Do you have the copy of the land reforms manual?
Yes, I have got the.
Please give me a copy of the land reforms manual and the land reforms act.
আমার তো বড় বই আছে।
আমারও বড় বই। Lordship will take this book, my lord. Manual টা কোথায়?
Manual, your lordship kindly, what is the purpose of the manual? Lordship kindly. On the earlier occasion, I have pointed out to your lordship for what purpose the manual has been framed. Rule 3, your lordship kindly come.
Please give me a minute.
Yes.
No, your lordship has got a copy of the manual.
Manual, please give me a copy of the manual.
Yes. Manual cannot be the act.
You have a copy of the manual?
I read that. Oh, বইটা কাটলাম। ট্রাইব্যুনাল নিয়ে তো হারিয়ে গেল।
জাজমেন্টটা পাঠাও আমাকে।
Mr. Banerjee, this manual is under what provision of the statute?
Manual, my lord.
Please show me from here under what provision of the statute? Because please kindly come to the Land Reforms Act. One is power to make rules, that is section 60. Another is power to give state government to give certain directions
62.
under 62.
Yes.
Under what provision of the statute this has been framed?
My lord, kindly come to Rule 28B, my lord,
Rule
which has been considered in that judgment, second judgment. Rule 28B of the rules.
Yes. Rules. Do you have a copy of the rules?
It is there in
rules. Act page. Rule
28B was considered by the division bench.
Rule 28B. Land Reforms Rule 1965.
28. Just a second, Lord. Just a second. I'll just check. 28.
28A.
28A possible. I'll just 28A. It says. Kindly see, without prejudice to the provisions elsewhere contained in these rules, all lands or interests therein belonging to state government shall be managed and shall be deemed to have been managed by the collector of the district under whose jurisdiction the lands are situated in accordance with the
This is
framing.
Yes, it says, rule says that will be under the manual. Where is the statutory force of the manual?
Management of land takes us to directly to the act, my lord. Rule and act. Section 52, Rule 28A, and the manual. So it is not only manual. Distribution of land.
28A says this is as per the.
It is the procedure.
By being the
procedure to be adopted by the officers while not discharging the functions of the act and the rules. Now, Section 52 and Rule 28A are statutory in nature.
And Land Reforms Manual published by the Board of Revenue West Bengal being the rules for the time being in force for the management of government lands and estates subject to such directions as may be.
So manual is the third limb, my lord. First limb is not the statute, section 52, as per this second judgment.
For a larger bank, Mr. Banerjee, I think this has to be resolved.
Now, I was relying on the principle, my lord, that
division bank judgments.
But
the field.
If a judgment is, my lord, rendered without considering the previous judgment, my lord.
Larger bank say so. Which one is par inquirium?
No.
Will your lordship permit me to?
Because there are 3 division bench judgments. One holding the first one as par inquirium, second approving the first one.
Without considering that the second judgment.
The principles of interpretation is that while passing the last judgment, the court is aware of the previous judgments.
And that has been referred
But
also.
That is also a rules of interpretation because aware of the previous judgment,
but in spite of
not
being aware,
expressly, but approves the earlier one. Meaning thereby
doesn't consider it, my lord. It has to
but
consider it.
it approves the first one.
My lord.
So now which one to be let the larger
Without taking note of the second judgment, which already says the previous judgment to be per incurrium, if the subsequent judgment is delivered, so it is delivered without not considering the previous judgment. Aware of it, but doesn't consider it.
If it is aware, impliedly, when the earlier one is being accepted, means that the second one goes. If he is aware.
Not aware is not the principle adopted that court is supposed to be not in helm of
deemed to be aware.
Deemed to be aware, but the judgment has to be not at least dealt with. If it is not dealt, in spite of being aware, if it is not dealt with, my lord, can it be held that it shall be deemed that the judgment has been held to be bad?
And what it was, this 28A was considered in the last judgment of July.
And the second bench could not have held it to be first one to be good. The only option available would have been to send it to a larger bench. For the second last judgment, what was the remedy available? There are two judgments contradictory. The court could have sent it to the larger bench, so it was not placed before their lordships, possibly. The second judgment was not placed. Had it been placed, my lord, court might have referred it. It cannot say the second judgment to be per incurrium, because per incurrium is when some particular thing is not taken note of, a statute. Second judgment is only section 52 and 28A. These are the two provisions which refer to the manuals. And the provisions also contemplate distribution of land.
Paragraph 80.
Justice Mukherjee's judgment was delivered on what context?
It was,
That was also on distribution of land or on
ferry.
Not distribution of land.
Ferry tender notice was issued, and it was held that that was issued on the strength of the manual. That was before the tribunal. Tribunal held. Thereafter, the division bench judgment.
Court has held, my lord, kindly come to the third page. Court has held that we are of the considered opinion that the notification, Justice Mukherjee's judgment.
Paragraph?
Sir, it is not paragraph. It is a SCC online copy, my lord. It is after recording Mr. Ashok Kumar Banerjee's submission.
Yes. We are of the
considered opinion that the notification was issued by the district land and land reforms officer, not as an authority under a specified act, but for and on behalf of the government committee for settlement of tank fishery. While issuing the said tender notice, he was not exercising any power under the West Bengal Land Reforms Act 1955. That is a specific finding that there is no, it is not exercised under any power. In this case, my lord, sections 52 and 28A are attracted, which was not attracted in that case.
No, but the concluding observation is important. The West Bengal Land Reforms Manual is nothing
but a compilation of
administrative instructions.
It was not framed
under the West Bengal Land Reforms Act. Specific
it was not framed under that. But if
so, if it is not framed under that act, then because only the act is the specified act.
Specified act.
So if it is not framed under the act, when whether the tribunal should be the forum.
In the present case, in the present case, my lord.
And please show me the finding in Justice Banerjee's petition bench order. With regard to this manual, that part.
Lord, kindly sees paragraphs, my lord, 12 and 14, which sets out section 52 and 28A. Then
12 and
14. 13 is also important, my lord. 13 says tank fishery also. So settlement of land, ferries also comes under it. 12, 13, 14. It holds that settlement of ferry is also under 52. Then paragraph 15.
এটা তো
হ্যাঁ স্যার রমেশ সত্য হ্যাঁ তার ভুল হচ্ছে এটা মোসাফর ধীবর সমবায় উমাকান্ত হালদার
এটা লিখে দাও।
No, under 52, rules have been framed.
52 rules.
52(4) says until rules framed under this section comes into operation, rules have been framed. Then management shall continue to be made in accordance with the existing law.
My lord.
So once the rules are framed, what is the effect then? 52(4?
Not assuming that the manual has no application after my lord, rules are framed, then also my lord, the function is statutory. 52 read with rule 28A. So the function of distribution of land is statutory. Manual is to guide. If not, I go by the submission of my learned senior friend that it is not under the rules. But Lord, I pointed out section 8 on the last occasion, my lord. Section 8 says under the specified act or any
Of
matter.
the, Land Reforms and Tenancy Tribunal
Tenancy
Act.
Tribunal Act, yes. Or any matter connected with land reforms. That my lord takes under its sweep anything connected with land reforms.
Section
8 of the Land Reforms and Tenancy Tribunal Act.
Exclusion of jurisdiction.
Or any other matter under any provision.
Or specified act.
Then
in relation to accused trial dispute related to
land
reform.
First part is land reforms.
And any other matter.
Or any matter connected therewith. So first part is anything connected to land reforms. Second part is specified acts.
It's better, Mr. Banerjee, it is to be referred. Because this issue, three conflicting judgments of the division bench.
But one thing may I pray, to add it. Just have it judgment are out.
Another judgment?
Yes. Your Lordship kindly say. I will refer my lord. My lord, you I remember. My lord, when the my lord Taj Bengal Hotel was established.
Give me.
My lord, the matter was my lord went up to the Honorable Supreme Court. Now the Supreme Court, my lord, there also the plea was at that point of time land management manual was there. Now paragraph 31, my lord, the Honorable Court, my lord, discussed about it. Paragraph 31, straight I, your lordship kindly come.
That citation to কত sir?
It has AIR 87 Supreme Court, page 1109. The Honorable Supreme Court said it is a compilation.
87 Supreme Court.
And your lordship kindly AIR 1987 Supreme Court 1109.
Admit it's a compilation.
Yes, compilation.
My submission is that it is regarding land reforms. Rule 3 of land manual says it's regarding land reforms. And section 8 says anything connected with land reforms.
And all these arranged in such manner reference to them by the officials revenue hierarchy is easy, statutory order, no doubt, to be obeyed. It does not mean that the other order instruction may be departed from the individual. Well, it has been dealt with, paragraph 31, 32.
No. This
is a compilation, nothing more, nothing less.
No. There are two aspects of this matter. It's nothing but a compendium of statutes and rules. There is no dispute with regard to that. And these are to be obeyed. There is also no dispute with regard to that.
Yes.
But the question is whether it falls within any matters connected with the specified act. Because the
regarding land
act says as per the rules.
Yes.
So principles of distribution, section 52 says how it is to be managed.
52 does not say about the distribution. Your Lordship kindly.
Thereafter rules 28A.
No. Your Lordship kindly just be a section 49(1), my lord, provides for settlement of land when the land is under the disposal of the government.
Yes.
Section 49. Now that is by way of patta. That is without premium. But under the Land Reforms Act, my lord, there is no provision that there is no provision with regard to the long-term lease. Long-term lease provision is there in the manual. In the manual. And when, my lord, the long-term lease will be there, that for the purpose of, in respect of the non-agricultural land. Your lordship kindly see, my lord, the rule, chapter 15 of the manual. Chapter 15 of the manual. Your lordship kindly.
rule 220 F6.
Yes.
Rule to Rule 20A6 is also there.
Rule 20A6 speaks about section 49 in connection with 49(1). Rule 21(6), my lord, will be dealt with in respect of section 49(1). That is patta.
Rule.
Rule, my lord, 215 of the manual. Your lordship kindly see. On the last occasion, my lord, chapter 15. এই বইটা দেবেন, তোমার বইটা দাও তো।
Rules.
Yes. কালকে বইটা আমার চুরি হয়ে গেল। Your lordship kindly see. এটা just
Yes.
Your lordship kindly see.
Rule
20.
Capital A. 6.
Rule 20.
Capital A6.
Yes. Rule 20A provides, my lord, your lordship kindly come, Rule 28A first.
Yes.
Terms and manner of settlement of land at the disposal of the state government under section 49.
Yes.
Settlement of land which is at the disposal of the, have you got it, my lord?
Yes.
Settlement of land which are at the disposal of the state government may be made by the collector of the district, such and such officer. Such settlement shall be made on a permanent basis, and the person with whom settlement is have been restriction imposed, such and such, section 49(1) of the Act. This provides, my lord, with regard to the settlement under section 49.
Yes.
Section 49 of the Land Reforms Act. Your lordship kindly come then, come, section 49. What the section 49 says? Your lordship kindly come. Section 49, your lordship kindly come.
Yes.
Principle, have you lordship got it? Section 49.
Yes.
Principles of distribution of land. Notwithstanding anything contained elsewhere in this act or any other law for the time being in force, settlement of any land which is at the disposal of the state government shall be made without any premium. Your lordship kindly marked it. Being charged for it in such manner as may be prescribed with the person who are residents of the locality where land is situated, who's together with the members of the family, such and such. These are the provisions. And for the purpose of area 1/2 agriculture Borgada, such and such. This is the, my lord, the provision of the act.
Yes.
So land should be under the disposal of the government. Now your lordship kindly come, section 14(3). I am a Borgadar, my statutory right has been crystallized. The statute says that I am a Rayod in respect of this property. Section 14(3). Your lordship kindly come.
Yes.
What is my case? First of all, your lordship kindly, what is my case? And what the tribunal has said? And what prompted me to make an application before the authority?
Yes.
Yes. Section 14(s), your lordship come.
Yes.
Vesting of land in excess of selling area. Now, your lordship kindly come. 3, subsection 3.
Yes.
Every Borgadar shall in relation to any land which is authorized under section 2 to retain under its cultivation became on and from the date of commencement of the provision of this act as Rayot.
Yes.
I am a Borgadar. Land has been vested under the Land Reforms Act. Under the provision of the act, I have been treated as a Rayot in respect of this property. Now, my lord, when, my lord, I apprehended that land may be, my lord, transferred to the others, I filed a suit for a declaration on the strength of the section 14(3) of the act for a declaration that I am a riot, it should be declared with permanent injunction. That suit in that suit, state was the party, collector as well as the BLRO. They appeared. Thereafter, the suit was decreed in my favor with the declaration that yes, I am the riot in respect of this property, and state was permanently restrained, my lord, by an order of injunction. Thereafter, I preferred an application for correction of record. That was not acceded to, which prompted me to, my lord, the travel before this tribunal. Now the tribunal, before the tribunal, my lord, elaborate judgment was there. They, my lord, learned GR also contested the matter, and after considering all this, learned tribunal directed the BLRO to consider my application for correction of the record of right. That was within the time frame. That was not considered. I prayed, my lord, I made an application, contempt application was there. Before the contempt, at the contempt proceeding, my lord, BLLRO submitted a report by saying that my hands are tied because the land has been settled by a long-term lease in favor of the Punjab National Rural Development Trust. So unless the land is free from encumbrances, my lord, I could not do it. Thereafter, what is the order of the tribunal? Your lordship, kindly see the order of the tribunal.
No, what are you challenging here? You are challenging
now,
long-term lease settlement.
Now, your lordship, kindly come page 69. It will be clear. Actually, it will be clear. 70. Page 64. First, your lordship, kindly come page 64. What is the parent order, mother order of the tribunal? And page 67 is the relevant part. Accordingly, have you lordship got it?
Page 67.
7. It starts from 64. 67 is the relevant part.
Yes.
Accordingly, BLRO is directed to dispose of the representation in accordance with law as expeditious possible, preferably within for the communication of this order.
Yes.
Now, your lordship, kindly see. Now, your lordship, kindly come page 69.
Yes, I've seen page 69.
69. Now, relevant part, your lordship, kindly see. Page 70.
Yes, I've seen that. So it says that unless it is cancelled, nothing can be done.
Yes. Thereafter, your lordship, kindly see last paragraph. Be that as it may, this order will not debar the applicant for taking appropriate step before the appropriate authority for getting constable justice. After all, their legitimate right under section 14S3 is undisputed.
Now you are challenging.
You
want cancellation of that
yes,
lease.
Yes. Because land is not under the disposal of the government. Yes. Land is under the disposal of the government. It is not.
Now this lease
yes.
was granted in exercise of what power? Where is that lease?
I have annexed it because
page,
they have
page,
my lord. In the name of governor, it has been done. Page 47, they have supplied it. Report. Xerox করেছো দাও জেরক্স দাও আদর তেরি তোমাকে নিয়ে করা মুশকিল আছে এটা কই আর কপি করোনি BLLRO expressed his helplessness unless it is cancelled. And ₹1 premium is ₹1. Premium is there, and it has been done in the name of governor.
Now, Mr. Banerjee, this lease is under what provision?
It has to be under 52, my lord.
Under
52.
If 52, it should be under the disposal of the government. The land should be under
that
the
is the
disposal of the
dispute,
government.
whether it is under disposal or not, my lord.
That's not a dispute now.
No.
You cannot dispute because the civil court has declared, tribunal has also said. You cannot say it's at the disposal now because you have not challenged that order.
Yes. My lord, if the deed is challenged, my lord.
Mr. Adjudication is there in the suit. A decree is there.
My lord.
Tribunal also says that right is preserved. Now you cannot say it's dispute. So if it is not in dispute, it cannot be at your disposal. So it cannot be under 49.
No, not 49, 52.
Not 52 also.
52
then your lordship will be holding.
Show me 52.
I understand. Your lordship will be holding, lord, that it is not a lease under section 52.
Cannot be. How can it be under 52 then?
Then your lordship will have to hold whether it is under the specified act or not. That is also an adjudication.
So what adjudication? Could not have been. It could not have been under 52 in view of the language.
Yes.
In view of the clear language.
Yes. 52 subsection 2 say at the disposal of the state.
Yes, cannot be at your disposal.
It is not disposal.
Cannot be at your disposal when he is the
or held under the state.
Yes, cannot be.
It was not the land.
Rayat will give lease to another person, affecting his right.
No, the action might be under challenge, but fact remains, my lord, land at the disposal or held by the state.
No, there are
These
two
has
things.
been given
If
for
it is not under 52, cannot be under the Land Reforms Act.
Then it has to be adjudicated, my lord, that whether it is
no expressive 40 days. If that order is not challenged, and there is nothing in the lease deed which says
then
that it was under 52.
Then I'll file an affidavit because our specific stand, since lease is given, our stand would be that it is under 52. Then the bank also has to be
because
your lordship directly
you kindly come to 52.
Bank is not traceable. How he is saying that bank is traceable? Mala, repeatedly I have sent it as per your lordship direction. Again I have served. Again I have served. Endorsement. Return to the sender.
No, it has to be correctly addressed.
লিজে যার অ্যাড্রেস আছে সেটাই অ্যাড্রেস তাহলে কি সেই ব্যাংকটা কি ফ্রডুলেন্ট ব্যাংক
Your lordship directed to serve at the correct address.
Where I will get it?
So you will have to get the address of the bank.
Yes, I have searched it.
If the bank changes its address, they'll have to ascertain that.
Bank changes its address, bank goes, he has served.
Yes.
He cannot run after the bank. If it is set aside, bank will come.
Yeah. I understand what fell from your lordship, whether it is under 52 or not. If it is under 52, then the question comes whether it is under the specified act or not, or under the
then the conflict of those decisions.
So kindly allow me to file. Then I'll have to file because the lease is there. The lease is under challenge. Although they are not directly challenged, the prayer is
Land Reforms Manual is a compendium of certain directions. Some may be directly under those provisions. Some may be outside.
Now, on that I have a submission.
Outside that.
Then also, madam, in my humble submission, kindly seize me, lord.
Then it cannot be matters connected to land reforms.
No, kindly come to rule 3 of the land reforms manual. Anything connected with land reforms, it says specifically.
No.
Kindly come to manual, my lord, once.
Manual, yes.
3.
Manual is in this book. Yes. 3.
This manual lays down principles and procedures to be followed by officials and functionaries in matters relating to land and land reforms. So it is entirely for land reforms. And section 8 says in connection with land reforms. So there's a connection between section 8 and this rule 3 under the manual. You cannot say that if it is not under the specified act, then manual completely goes, in my humble submission. If these two are not read together.
All right, you take instructions with regard to this.
Regarding the lease. Whether it's nature of the lease.
52 or not.
That is a question. If it is not, then
14 years is staring at your face. So if it is 14 years,
then it will be an adjudication on merit, whether the lease is under 52 or not.
No. Mr. Banerjee, what will be adjudicated?
Lease is under challenge.
What will be adjudicated if there is a dispute? As on this date, there is no dispute that he is a Rayat under 14 years. You have not challenged.
Yes. No, whether the lease is issued under the provisions of Land Reforms Act or not, that is also a question.
This is not in dispute. He is a Rayat. It is not in dispute. You cannot now dispute that because you have not challenged that adjudication.
That ex parte decree.
Ex parte, they have appeared.
Maybe ex parte degree is also a degree, Mr. Banerjee.
Yes,
unless it is set aside. Unless it is set aside, it is a degree operating against you.
My lord.
And thereafter, Land Reforms and Tenancy Tribunal also recognizes that. that his right under 14X is unchallenged. So if that is so, now whether that power can be exercised,
Now,
can it be said to be 52?
whether it is an incorrect exercise or not, that is one question. But whether there is any other provision for giving lease, if there is no other provision,
You have a power.
it is a lease under 52 wrongly given.
One thing is you have a power, you do not exercise the power in accordance with law. That's one thing. Second is, if you do not have a power under that provision, exercise, it's without jurisdiction, non-est in the eye of law, nullity.
Lease given under 52 without having the
Do not
power.
have the power. It's nullity. All acts are nullity. All acts are nullity. Need not even be challenged. Only a declaration is sufficient. Because if you do not have the power, once you have the power, you exercise it in this way, that way, not in accordance with the statute, that's one thing. Then he has to challenge that. But if you do not have the power, use up some power, that's nullity. If you don't have the power, you do not have any right to exercise that power.
So no, only limited to 52 minutes, and I'll take this point also, because if it is 52, then this point comes. Otherwise, if it is not 52, then these points will not come.
This point
I want a final education on this point, whether it's maintainable or not. Otherwise, because one point not considered is this relating to land reforms. The word used in section 8 regarding land reforms, vis-a-vis rule 3.
Yes, land reforms. It is at the disposal. It has to be under any provisions of the Act or the rules.
That is on the facts of this case.
Yes.
In
fact
general,
of this case, if it is not under 52, then we need not go into those controversies.
Yes.
Otherwise, then it has to be referred. The other way, it has to be referred. Because there are conflicting division bench judgments.
I'll file an affidavit in opposition, Milord, because since the lease deed is under challenge, Milord, it should be an
Court
affidavit.
will also do in affidavit, same thing.
Let it appear as a motion, but not let them file an affidavit, because all are factual allegations.
What
Regarding Milord,
nothing is
they are absolute.
Mr. Banerjee, only you will have to say, I have exercised power under this provision. Everything are admitted. 14 years, Raat, everything you have executed, everything is admitted. Only exercise of power under what provision? That's only you have to spell out. That can be two lines.
This is not the stand of
line
the,
affidavit.
that is the
Nothing is
stand of the stand of the petitioner is not that his right is not beyond any doubt. But what is
Not
the stand of the state? While
the order binding upon you, you are a party. It's an order.
I'll have to
not his stand.
I'll have to deal with those orders. What happened subsequently, whether any further order is there, anything is there or not, I have to deal with. I have to deal with
that in the report.
State appeared before the trial suit.
Considering the nature of allegations contained in the writ petition, Mr. Banerjee, learned advocate appearing for the state, submits that Mr. Banerjee, learned advocate for the state, prays for a direction to file, prays for liberty to file a report dealing with the allegations contained in the writ petition. Full stop. Letter as paid for by Mr. Banerjee, letter report in the form of an affidavit be filed by
3 weeks.
3 weeks.
Who will file?
5 minutes.
the division bench.
But in place of 10, it will be 11.
Deemed proper on my part to take on that.
Deemed overruling of the previous
Okay,
judgment.
one minute.
Deemed overruling of the second judgment by the third judge.
Deemed overruling of the, because the subsequent bench must be deemed to be aware of the previous judgments.
But has to be on record, has to consider, at least there should be one line
There are
that.
two views,
consider.
Mr. Banerjee, because if it is aware, implied overruling, implied,
11.
those may come into, so it's better the larger quorum decides this.
Let it be on 11th, my lord.
11th.
11th.
This is my application, my lord. This was mentioned last Thursday upon notice.
Yes. Upon notice.
This was mentioned upon notice.
Yes, who is appearing?
Initially, Noel Banerjee was appearing.
Yes. Yes.
The Lordship, in this matter, Mrs. Noel Banerjee is appearing for the state response. She is in personal difficulty today. Can it be any another day?
Milord, I am logged in, but Milord, unfortunately, Milord, I am on my way back from NCLT. I won't be able to reach. Any day, Milord, I can appear.
Let me start. Let me start. Because it will take time. It will take
No,
time.
no. No. Milord, kindly, Milord, I'm driving. Milord, kindly another day. Because it's an absolutely bogus application, Milord.
An accommodation has
Don't say on the prayer runs.
29th.
Milord knows this, what happens.
I am for the petitioner, my lord. I served upon all the respondents. This is a removal of the unauthorized construction over the PWD land, my lord, state highway land.
Yes.
The petitioner made objection, my lord, page 33, annex P3, my lord. That may be considered by the
page
33, my lord. It starts from page 33. All addressed to all the competent authorities.
Petitioner claims to Yes.
I'm for
You're
the
for the
response.
respondent number 13.
I'm for the 14, my lord.
15, my lord, respondent number.
You are for the
15, respondent number.
respondent number 15. Mr. Day for
For 13, 12 and 13.
Lord,
private
I am for
respondent.
Lord, I am for private respondent number 14.
14. Who is for the petitioner? None appears.
Yes.
None appears for the petitioner at the time of call. No.
My lord, affidavit of
Mr. Day, please ask your learned advocate to supply the names. Yes.
My lord, very innocuous here, petitioner is a recorded owner of 25 decimal of land. My lord, the private respondents are the adjacent plot holder, my lord. Every time they encroach the petitioner's land, petitioner praying before the bearer to provide a amin in his cost.
Where is the provision? Under which statute? A demarcation of a private property by a government. I mean, show me the relevant provision in the statute.
As per the Land Reform Act.
Show me Land Reforms Act. Which section provides vest powers upon the block land and land reforms officer to depute amins for demarcation of a private property? Please show me. Which section of the Land Reforms Act? Din Land Reforms Act. To demarcation, file a civil suit. There's a dispute as to demarcation, file a civil suit. Where is the provision? Show me. Unless you show inaction on the part of the authorities under a statute, it is not maintainable. Please show me.
My lord, I made a representation to the
Representation, show me that their duty to consider that. Where is that? We are making a representation does not give you a right.
Well, give me 1 day time, my lord. I will satisfy my. Make it not today only. I will satisfy my.
Yes, Mr. Mahato, you are appearing. Yes, what is the submission?
রবীন্দ্রনাথ কুণ্ডু দেখুন দেখুন আমি দিব কপিটা আমার একটাই আছে দেখুন বিএলআর রিপ্রেজেন্টেশন দিয়েছে সরকারি আমিন দিয়ে আমার জায়গাটা একটু আমার বিএলআর একটা রিপ্রেজেন্টেশন দিয়েছিলাম সরকারি আমিন দিয়ে আমার জায়গাটা একটু মেজর করে দাও এটা রিপ্রেজেন্টেশন
My lord, he has made the representation to the authority under the specified act.
For demarcation of private property between two private
My
parties.
lord.
Consider that. Cannot be considered.
My lord, he has to approach the tribunal.
No, but Mr. Mahato,
My lord, yes, this is
provision in the
the
statute for demarcation.
no, only government land demarcation provision is.
They want private property.
Private property, my lord, the BLR has no authority.
That's his representation. Please go to page 57. প্রাইভেট আমিন দ্বারা মাপা সত্ত্বেও অপর পক্ষ মানিতেছে না। Now he wants a government amin. Demarcation.
Then both have to apply. Both unless the both.
Where is the provision, Mr. Mahato? Under
there is no provisions for demarcation of the land by the.
If you voluntarily do that, but the court cannot direct you.
My lord.
Awesome. The petitioner Yes, 38. Yes. Who is appearing? None appears for the petition at the time of yes. Yes. Yes, Mr. Dey, what is your instruction?
The Halisahar municipality is the answering respondent. Right, objection which petition.
None appears for the petition at the time. Yes. The item number 40, Mr. Dey, you are appearing. 40, you are appearing? No.
No, I am not. Deval Kumar.
None appears for the petition at the time.
Number 41. Item 41, I am for the petition admiral.
Yes.
Praying for not today.
Yes, yes, please move. Yes, what
But-
is this matter?
I am not an advocate on recording order. Mr. Ziaul Haq appearing in this matter. He is engaged in another court. His personal appearance there, so he could not come due to.
The petitioner.
My lord, item number 40.
Which item?
Your lordship dismissed item number 39. But today, in today's list, my lord, that matter is item 38.
Item?
Item 38.
Item 38.
Yes, ma'am. So, my lord, your lordship, I pray, my lord, to call, otherwise, my lord, to miss.
Yes, yes. এটা কি monthly stick supplement?
I am appearing for the state. I was coming from court number 12.
40, what happened?
40.
My lord,
It has been
today's
disposed of.
Today's 39 to the
Today's list 39.
Yes.
39. 39 is same as which item?
39, my lord.
Yes. Today's item 39 is same as which item? Monthly list which item?
Monthly list, my lord, item number, এটা কত 38 monthly list দেখো নি my lord, yes my lord, your lordship can pass. Yeah, ঠিক আছে ঠিক আছে.
Yes.
My lord, item number 40, my lord, I am appearing for the state. I was coming from court number 20.
What happened to item number 40?
It has been disposed of today.
Oh, this matter?
Yes, my lord.
Oh, তাহলে ওনার নামটা রেকর্ড করে দিন।
40.
করে দিন। যেটা কি
42, my lord, I am appearing for the petitioner. My lord, now, my lord, I already filed, my lord, no objection, my lord, no objection already been filed. My lord, kindly 1 day accommodation, my lord.
No objection. You have taken a change or given a change.
No, my lord, I already, my lord,
Then you are ready because
my lord,
after holding conference, you have taken no objection.
my lord, that file, my lord, is not with me at this moment. My lord, only 1 day accommodation.
The file, no objection. Vakalatnama
No,
cannot be
that is with me, my lord, that is in chamber. My lord, only 1 day accommodation.
Client comes, you hold
Yes, yes.
conference,
My lord,
you
that
know
is-
the matter.
My lord, only
When
1
it is
day.
appearing,
My lord,
then
I-
no objection. Vakalatnama
I-
is executed.
my lord, I have
Please
to.
do not tell those stories to at
My lord,
least
I
to
have
me.
to gone through the matter. My lord, only 1 day accommodation.
Say so, that's the other thing. Please do not say that I have executed no objection, Vakalatnama file. Please do not tell those stories to
My
this
lord, that-
court.
1 day accommodation, my lord, only.
Tell that, yes.
Material instruction due.
Material instruction, I will not say anything, but unless that is assured, no objection is not taken. Take it from me, ask her outside the court. Yes. Not today. On the prayer of the learned advocate for the petitioner. The hearing of this. Yes, call the next matter.
For the respondent number 4 came.
Yes, yes. What is this matter, Mr. Talukdar?
My lord, in fact, my lord, nothing
against you.
Nothing material has been. And
what is the prayer?
Either the averment or the documents which can be considered. The stateway, the petitioner prays for disbursement. He alleged to have purchased the land from various persons in 22-24.
Yes. These plots were acquired.
That instruction, my lord, I need to take because nothing has been annexed to
Appears
show.
for the petitioner at the time of none appears.
My lord, I am for the state.
Yes. Yes, what is the prayer? None appears for the petitioner at the time.
Lord, item number 45 to 48, similar matter. My Lord.
Yes.
I am for the petitioner, my Lord.
Yes.
My Lord, here, my Lord.
Who is appearing? Mr. Mahato, you are appearing.
In 47, my lord, I am appearing.
This is item number
45, my Lord.
45 to 48, same matter.
Same matter.
Mr. Mahato, you
My
can
Lord,
appear.
section 25, 28 application was filed. It was not disposing of, my Lord. That is why, my Lord, I have come before your lordships for, my Lord,
Dispose of the
particular
section
prayers.
28A, Mr. Mahato. What is your instruction?
My lord,
Which matter you are appearing? 40?
in 47.
47 file ta din. What is your instruction, Mr. Mahato?
My lord, I have not taken the instruction here.
Dispose of section 28A.
Section 28A, my lord, yes. But section 28A, my lord, certified copy within 3 months. Though it has been, application has been made in 2010.
2010.
Pass an order, communicate the decision.
Order to
Dispose of. I am not saying that.
My Lord, one, my Lord, prayer, my Lord, before your lordships. Your
Yes.
lordship kindly, my Lord, direct my learned friend to, my Lord, pass order in respect of prayer A, B, C, D.
A, B, C, D.
Yes, my Lord. My
Dispose
Lord,
of the application.
what
What is
is
B?
what is happening, my Lord, in this matter, my Lord? My Lord, my practical experience says, my Lord, they will, my Lord, take hearing and not, my Lord, communicate with you what is the order, whether I have failed or.
Mr. Mahato, the order has to be communicated.
Order has to be communicated.
So I'm directing you to dispose of this matter.
My lord,
My Lord, with
Application
calculation.
filed on 19/11/2010.
yes, my lord.
All right. The petitioner Yes.
87 of 2007.
45 টা সেম ওনার নামটা রেকর্ড করে দিন, none appears for this. Please give a copy of the writ petition to him.
Milord, just no, Milord,
ঠিক আছে,
I
দিয়ে
have,
দিন, দিয়ে
In
I'm
course of
positive.
this
Yes,
day,
Milord, in course of.
I'm grateful, Milord.
45, 46.
I am for the petitioner.
Who is for the state? 46.
ঠিক 45
Yes, you appear. 40, 46.
ভালো
File দিন।
I'm grateful, Milord.
46 এ ফাইলটা দিন। Which paragraph?
Milord, I am. Milord, paragraph 9,
Case
Milord.
number is 199 of 2006.
Yes, Milord.
আর ওই matters Disposed of your. Yes, sir. All matters?
Yes.
Yes. Up to 48.
Up to 48.
Yes, call the next matter. None appears for the petitioner at the time of.
Council Mr. Piyoboto Botobal is appearing on behalf of the state, but he could not come because one of his relatives died yesterday. That is why he could not
You are
come.
his
Kindly,
junior, yes. What is this matter?
The matter is infectious, my lord.
Infractious.
My lord.
The
My lord,
learned advocate appearing for the petitioner.
Priyanka Mondal is appearing for the petitioner. He instructed me to pray for an adjournment.
Who is appearing?
Priyanka Mondal, Lordship.
I am for the state.
Bikramjit Mondal is there.
Sadhya, what is your instruction?
I have no instruction, my lord, up till now. Correct.
31st of July 2020. Order passed under section 50. How can it be challenged in a writ petition?
If I have no instruction, Lordship, he requested me.
The learned advocate, Mr.
I am for the
You are appearing. আচ্ছা ওটা রেকর্ড করে দিন মিস্টার দে লার্নেড অ্যাডিশনাল গভর্নমেন্ট প্রিডেড অ্যাপিয়ার্স
I am for the state, my lord.
Yes.
My lord, this is an application, my lord, where my lord, the petition has come before lordship, my lord, challenging an inaction on the part of the state authority, where my lord, the private respondent had encroached upon the my lord, PWD and government land, just blocking the ingress and ingress of the petitioner.
Where is your representation?
My lord, it's at page my lord, 20 is my representation. My lord, the last occasion, my lord,
There was a direction upon the BDO to file a report. This is the report, my lord.
BDO?
এটা কত? 52.
52.
কি নাম বলুন তো?
Shahidul say.
Sorry, my lord, এটা অন্য ম্যাটার ঢুকে গেছে। 52 তো ছিল না, 52
Huh?
52. Combined with one. তাহলে বলছেন সেই দিন
নাম্বার দেখো না, কে নাম্বার মিলিয়ে নাও? My lord, I will beg.
26,933
Prayer.
My lord, this is
Recording the name. How a writ petition is maintainable for that?
no, my lord, this is 27168. 27168.
এটা monthly
Combined list.
ওহো এটা monthly list.
Oh, I beg.
হবে না
Who is appearing?
I am for the state, my lord.
You are for the state?
Yes, my lord.
None appears for the petitioner at the time of call. No accommodation has been sought for either. State is represented by its learned advocate since the petition.
Well, I am for the state, my lord. I need instruction, my lord.
In this matter, what happened, Lordship? The PWD purchased and had donated some by person 2 shatok of land, Lordship.
PWD donated?
Some person donated 2 decimals of land, Lordship.
To the PWD?
To the PWD behind my Lordship plot of land. Now the said plot has no access. What the PWD has done, Lordship, they forcefully, Lordship, detained me in the police station and by JCB broke my boundary wall and now using the way the plot as path of land. Kindly consider I have annexed the photographs, Lordship, at page 57. The boundary wall was destroyed by the PWD authority.
Yes, what is your instruction?
Well, I need instruction, my lord. I pay some time, my lord, to take instruction. Otherwise, I cannot open my mouth.
This was served when?
My lord,
December 2025.
I have also called for instruction, my lord, but not at this, my lord. I have also called.
How long the instruction will take?
This is Murshidabad, my lord.
Yes, Murshidabad is not outside West Bengal.
That's true. That's true, my lord. That is within hand. So give me 2 weeks time.
How much time?
2 weeks time.
Why? 2 weeks time? Why? You have demolished a boundary wall and now you want 2 weeks time.
Well,
You must be knowing all facts. Pictures are there. Instantly it will come in your mind what happened. 2 weeks is not necessary.
More 10 days.
When it was served upon you, when you have served, Mr. Sarnal.
I just handed over the service
Well, sir, I also called for information, my lord. Twice, my lord.
No, you may have called for, your officers may not have given.
12th of December, Lordship, it was.
That
sir.
is why
12th of December, what is the date today?
Well, that's true, my lord. I cannot deny, my lord.
Yes,
So even
19th.
then I need some time.
The learned
any date.
Yes.
$54 ml.
Srinath.
None appears for the petitioner at the time of
Petitioner, my lord.
My lord, I'm for the state restaurant, my lord. Today, my lord, we have no brief.
Average service.
yes, yes, yes.
My lord, in this matter, my lord, the land of the petitioners were vested in the year 1999. But my lord, the walk of disbelieving the walk of Nama. My lord, that was got to be challenged.
Appeal is pending. You want disposal of the appeal.
Appeal, my lord, that has already been assigned before the subdivisional land and
That's pending.
Pending, my lord. One date has been fixed.
Yes,
But in the meantime, my lord, my lord, that has been taken over by the my lord,
Now pending before which respondent?
my lord, respondent, my lord, that was not assigned till that date. That was not
Now it has been assigned
assigned by subdivision officer.
to
After
subdivision
filing,
officer.
subdivisional land and land officer, that has not made party, my lord, because that was filed before the
Subdivisional
land and land reforms officer, SDLRO.
appeal under what provision?
55, my lord. My lord, kindly annexure, my lord.
Please show me. Where is the appeal petition?
Page number 39.
Number
39 and
Miss appeal number such and such.
such and such. Yes.
Against what order?
West Bengal Land Reforms Act against the impugned order dated 1999, passed by the block land and land reform officer Khairasol Birbhum in Birbhum case number 7 of 1999. Page 30, my lord.
তাহলে হবে কি করে এখানে?
Liberty was granted by the West Bengal LRTT.
আরে ভাই এখানে হবে না।
But liberty was granted by the dispose of the appeal. Appeal is pending.
As you
The petitioner has sought for
order, my lord, in the meantime, my lord.
Then go before the tribunal. Now status quo.
এই একটা কপি দিয়ে দেবে
Milord, item,
Yes, yes.
item 56, similar matter is
What
running before,
similar matter?
similar matter as item number 71 and 102 of today's list, my lord. Same matter, but my lord, in 102 matter, my lord, the state government
Let
filed
us proceed one by one. What is this?
this
Who
is
is appearing for the state?
I am for the respondent number 2, corporation.
Corporation. You are for the corporation.
Yes, ma'am. Led by Mr. Sanjay Shah.
Yes. Who is for the state?
I have served a copy, my
Yes.
lord.
What have you prayed for?
My lord, we prayed for extension of my LOI period, validity, revalidation of LOI. But my lord, in 102, the item number 102, the state government filed a report where it is found, my lord, all the three lease application has been cancelled, recommend for cancel behind my back. For this is, my lord, I am praying for kindly fix all three matters. One day, my lord, on basis of report, kindly give liberty to challenge the afresh, my lord, because otherwise, my lord, my purpose will not be
You
served.
want to withdraw this to file afresh?
Liberty.
Along with all other matters also, my lord.
You want to withdraw all this to
Yes,
file
yes, yes.
afresh?
Liberty to file afresh challenging the
Challenging
report.
which order?
Report filed by the
Please give me the report.
Yes, yes,
What
yes.
are the two matters?
71 and 102.
71 or 102. You are appearing in the other all these
Today's
matters.
list.
No one is appearing for the state.
That I do not know. Yes, yes. One matter 71, my lord, Amol Sen appear, my lord, and 102.
This matter who is appearing?
One Bhattacharya appear.
This matter who is appearing?
This is first time, my lord. This matter.
You have served or you have not served?
Yes, yes.
Who is appearing? Please give me the copy of the report.
Report.
কোন পেজটাতে
Which order you want to challenge?
Minus of the report. Annexure. 102. Yes, my lord. Without opportunity of hearing.
The petition
The report maybe.
Report.
Well, it has been withdrawn. This matter.
হ্যাঁ
Yes.
এখানে একটা অন্য ম্যাটারে
আমার-
বল দিচ্ছি
আমার-
Appearances. You are from
Yes.
the state.
Yes, for
Yes.
Give your appearances.
It is my pleasure to appear before my lord. I could not get that opportunity. এই
All the next matter.
এই আমার নামটা আর আমার জুনিয়র কে আছে আমার
হবে না।
Yes.
এই তো দাদা কই? তো দাদা নাইলে তো হবে না।
Yes, yes, yes.
হ্যাঁ তো দাদাকে ডেকে নিয়ে আয়। নিয়ে বল।
Yes.
Mr. Roy is appearing, madam, he's on his leg now.
His competent juniors are before this court. Yes, Mr. Yes, Mr. Sannal. His competent juniors are before this court. Yes, yes. Who are raising objection as to the mentality? You are.
Yes, definitely, my lord.
Yes, yes. Make your submissions.
Now, my lord, kindly,
Because you have a first right of hearing. Who is objecting has a first right of
My lord,
hearing.
your lordship can take 140 first, my lord.
140.
Yes, my lord.
140 file ta din to aage.
দাদা 140
140 file ta din. 140 file ta aage din.
yes. Now, my lord, kindly straightway come to annexure P3 at page 21.
21.
Yes.
Yes.
This is, my lord, the order passed in the miscellaneous miss case number 2233 of 2024. Order is dated at the left hand side, my lord, 12th October 2020. Has your lordship got it, my lord? Now, my lord, this order has been subsequently, my lord, another order is there at page 23, that is order dated 28th of July 2021.
Yes.
My lord, kindly see at page 24, it has been passed by the prescribed authority under section 51F of WBLR Act 1955. The next.
51F, yes.
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 Now, this order is assailed, my lord, in an application under section in an appeal rather under section 54 of the West Bengal Land Reforms Act.
By you?
No.
By them?
By them. That is, my lord, by us, rather by us.
That is what I am saying.
That is by us. That is, my lord, at page 29.
Yes.
Along with the application under section 5.
Yes.
At page 29, the order is dated, my lord, 2nd May 2024.
Yes.
Now, the order reads, my lord, may I read it for your lordship?
Yes.
Being agreed with this order dated 22nd of January 2020, passed by the prescribed authority under section 50 of the West Bengal Land Reforms Act 1955, attached to the office of the BLLRO Murshidabad, Jiaganj, in mutation case number given, the petitioners have filed this appeal under section 54 of the West Bengal Land Reforms Act 1955. As there is delay to file this appeal, the petitioners have filed another application under section 5 of the Limitation Act for condonation of delay on the grounds mentioned therein. After going through the application, the delay is hereby condoned and admitted in RA number given. Here, my learned friend joined issue here. And I join issue, my lord, on the date of passing of the order. That is 2nd May 2024. Now, my lord, thereafter, another order was passed on 16th of January 2025. That is at page 30.
Yes.
And ultimately, my lord, the proceeding concluded by order number 4, that is dated 28th of February 2025. My lord, in the present writ petition before your lordship, they have assailed, my lord, both these orders dated 2nd May 2024 as well as, my lord, dated 28th February 2025. Now, my lord, may I place section 10 once before your lordship. Section 10 of the West Bengal Land Reforms and Tenancy Tribunal Act. Now, that is, my lord, section 10 is application to tribunal. Has your lordship got it, my lord? Number 1, subject to the provisions of section 6 and other provisions of this act, a person aggrieved by any order passed by an authority or any action taken either by an authority or by the state government may prefer an appeal to the tribunal for the redressal of his grievance. 2, every application under subsection 1 shall be made within 60 days from the date on which such order was passed or such action was taken, as the case may be, or within such further time as may be allowed by the tribunal. Am I clear? Now, my lord, if this order is taken into account, that is, my lord, the order by which the delay has been condoned, that is 2nd May 2024. Now, kindly come to the affidavit portion of this writ petition. When this writ petition was affirmed,
Yes.
it has been affirmed on 6th November 2025. So,
Beyond 60 days.
or 24th, my lord, it is 4th
60 days.
Not only beyond 60 days, no more, near about 1 year and
Beyond 60 days is 1 year is also beyond.
no,
2 years is also beyond.
yes, very badly barred by limitation. Now, if the ultimate order, that is, my lord, 28th of February 2025 is taken into consideration.
That is also barred.
That is 6 months goes, my lord, on 28th of August.
Beyond 60 days.
And this writ petition was affirmed on in the month of November 6, 2025. It was affirmed. So,
Beyond 60
beyond
days,
six-
accepted, no dispute. Please
now, my
proceed.
lord,
Yes.
what the Honorable Apex Court has observed.
Yes.
এর আর কপি কোথায়? Lord, I have only one copy right now, my lord. It's the case, my lord. It's the, oh yes, I have it.
What is the citation?
It's an unreported decision, Rikab Chand Jain versus Union of India. My lord, kindly take this copy. Lord, it has been decided by the Honorable Apex Court, my lord, on November 12, 2025. Now, my lord, what has happened, my lord, here, the, my lord, kindly see, my lord, the order, my lord, is the entire proceeding is coming, my lord, out of, my lord, a proceeding under the, my lord, that is, my lord, বলে আইনটা বলো না, ওই স্মাগলিং এটা হচ্ছে
Central Excise and
Central Excise and Gold Appellate Tribunal. Now, my lord, there, my lord, there is a provision for appeal. My lord, kindly come to paragraph 13. What happened? Kindly come to page 6, paragraph 13. Lord, their lordship says, my lord, that although, has your lordship got it, my lord? Page 6, Paragraph 13. Although there is no period of limitation for invoking the writ jurisdiction of a high court under Article 226, all that the courts insist is invocation of its jurisdiction with utmost expedition and at any rate within a reasonable period. What would constitute reasonable period cannot be put in a straitjacket, and it must invariably depend on the facts and circumstances of each particular case. Nonetheless, the period of limitation prescribed by an enactment, I do join issue here, my lord. Nonetheless, the period of limitation prescribed by an enactment for availing the alternative remedy provided thereunder in certain cases does provide indication as to what should be the reasonable period within which the writ jurisdiction has to be invoked. So the statutory remedy, here also the question, same question arose. The statutory remedy, the statute limits, the period of limitation is engrafted in the statute. So when you are leaving the statutory remedy and invoking the writ jurisdiction, you have to keep it in your mind that you have to come. What is the reasonable period? Reasonable period is the time limit which is engrafted in the statute. Here it is 60 days. Now, my lord, then their lordship says, nonetheless, the period of limitation prescribed by an enactment for availing the alternative remedy provided thereunder in certain cases does provide indication as to what should be the reasonable period within which the writ jurisdiction has to be invoked. Next, my lord, their lordship says, in the present case, the order of central CEGAT was subjected to challenge by the appellant well after the prescribed period of limitation for seeking a reference by making an application under section 130A of the 1962 Act as it then existed. Although an explanation was sought to be given by the appellant why the writ jurisdiction could not be invoked earlier, we are not impressed. The belated invocation of writ jurisdiction of the High Court could not have been justified by the appellant by taking the plea of pursuing remedy elsewhere. Even otherwise, such an explanation could well have been offered in an application seeking condonation of delay in presentation of the application under section 130A of the 1962 Act before the High Court. We have not found any provision in the 1962 Act which either expressly or by necessary implication excluded the provision of section 4 to 24 of the Limitation Act 1963. As such, in terms of section 29(2) of the 1963 Act, the High Court in its reference could have well been approached with a request to condone the delay in presentation of the application under section 130A of the 1962 Act. Here, my lord, there is a provision for appeal or reference before the High Court. They could have taken an application under section 5 of the Limitation Act for condonation of delay. That they left. They straightway they allowed the time to pass on. Thereafter, they straightway took out this writ petition. And there, my lord, their lordships hold, my lord, no. This writ petition, when there is a statutory remedy, there is a specific time limit provided in the statute. You abandoned that remedy. You did not avail that necessary, that period of time while you did not take in, keep it in your mind while that time limit, while preferring the writ petition. Now, this writ petition cannot be entertained. So, my lord, this writ petition, my lord, in other words, has been taken, my lord, in a much belated stage and without availing they even today, in my humble submission, they have a remedy before the West Bengal Land Reforms and Tenancy Tribunal, but they have to satisfy this litmus test under section 10(2) of the Act. Without invoking that, my lord, they cannot maintain this writ petition before your lordship. That is what my humble submission before your lordship.
Anything more?
Not now.
Yes, Mr. De.
এই জাজমেন্টটাই আরেকটা জাজমেন্ট যেটা বলছেন, yes, that is another judgment there, my lord, that is regarding, my lord, Armed Forces Tribunal. But there is a provision in AFT Act where the appeal lies before the Honorable Supreme Court. The Honorable Supreme Court, in a specific case, Honorable Supreme Court held, my lord, that no, you can approach the Honorable High Court, because it is not possible for a retired army man to approach the Supreme Court in each and every matter. Suppose an army man who is in a very low, I have it, I will give it, give me just 2 to 3 minutes time. That remedy, that the Honorable, but there is a specific reason that they are all retired army men, and they have served in a very low rank. So they are not major general or lieutenant colonel, not that. So it is not expected that such persons after their retirement will each and every matter they will come up before the Honorable Supreme Court. So like L. Chandra Kumar, let them exhaust their remedy before the High Court, and then they can approach the Supreme Court. That's a different thing. I'm giving it to your lordship, but this recap Chand join in my humble submission is not to the point.
Yes, Mr. De. Mr. Bhattacharya, you are for?
I am for only respondent number 7, one of the.
In one of the matters.
In all the matters, my lord. Only for respondent number 7. He is for other brothers. I am for only one brother.
Yes.
And may I am not joining issues with him. I am resigning 2 judgments. One of your lordship's judgment, 2024-1 High Court cases, Calcutta 180.
This is that AFT judgment. ठीक है नीचे
2024-1 High Court cases, Calcutta 189.
2024-1
High Court cases, Calcutta 189.
What title the
GL Kumbu and Sons Private Limited
versus
Deputy Commissioner of Sales Tax.
Mr. Bhattacharya, please give me a minute. Let me go through the Armed Forces Tribunal judgment once.
Versus Senate Commission.
Thousand 24 ACC online Calcutta 1175. ACC online Calcutta 1175. হ্যাঁ 2024 ACC online Calcutta 117 আর একটা হচ্ছে ACC 2022 ACC online Calcutta 4116
Yes. Yes, Mr. Bhattacharya.
This is a very short point, my lord's judgment, where an appeal under the West Bengal Goods and Service Tax Act was preferred before the Honorable High Court, since the tribunal was not functional at that time.
That's a different thing altogether. If the tribunal is not functional,
That time,
the writ petition is maintainable.
that time writ was filed, it was allowed, it was maintainable, but since the tribunal came into force, my lord was of opinion that
They have to approach the tribunal.
since the tribunal is functional at the present time, when the writ petitioner, we are going into the merits of the matter, which my learned senior friend said that whether it's section 5 is applicable or not before, but without going into
Section 5, very recently, the
Yes,
Honorable Supreme
yes.
Court has delivered
but
a
since
judgment.
without going into the merits,
7th of January.
yes, so that's
2026, the judgment
Forum
has been
has-
delivered. That issue has been decided now.
forum has to be
That issue has been now set at rest by the Honorable Supreme Court on 7th of January 2026.
What is the decision?
Section 5, whether it's maintainable or not.
Maintainable. That is our, that is,
There's a recent decision of the Honorable Supreme
যেটা আমরা গিয়েছিলাম
Yes.
Another is 2022 SSC online Calcutta 4116. It's also minor judgment. 2022 SSC online Calcutta 4116.
This is also when the tribunal was not functional.
Yes, that's I'm single.
GST tribunal was not constituted. It's not functional. GST appellate tribunal was not constituted at that relevant point
Only
of
that
time.
time.
Till now, it has not been constituted, formally constituted, but the members have not been appointed. So that's the present situation. This is a slightly different context altogether.
Here with the
This GST matters because
function.
after this act, the GST appellate tribunal was not constituted. That's the reason for.
These are the two judgments where I will be referring. Since the tribunal is functioned without going into the merits of the writ petition, the appropriate
Mr.
section-
Bhattacharya, there are, what is your answer to this? 226 and 227, even assuming that the tribunal is functional, if an order is patently without jurisdiction, whether the writ court can shut its eyes and say, no, no, no. Since there's an alternative forum, I will not look into this.
So there is a
Because an alternative remedy or exhaustion of the alternative remedy does not take away the power of the writ court. So if ex facie without jurisdiction, jurisdictional because you know, even if the appellate remedies are provided, there are certain 3 or 4 exceptional cases where even in spite of availability of the alternative remedy, appellate remedy, writ petition 226, 227, both can be invoked. So if it's a jurisdictional issue, then even if the tribunal is functional, then 226 and 227, subject to what you submit, is not an express bar. So if it's not an express bar, if it's without jurisdiction, 226, 227 can be invoked.
226 can be invoked. I am not on that issue, my lord, but this is a constitutional forum has been created by the words of the constitution.
Please show me, because 226, 227, all in statutes, very many statutes, alternative remedies of appeals have been given, power has been given, forum is there. Even then, writ petitions are being, as you have shown this judgment, this goes also against you. Tribunal not constituted, then goes. So, under certain circumstances, even if the statute prescribes the forum, writ petition can be maintained.
But here the tribunal is functioning.
Yes, but even if there is an appellate remedy, according to you, that's an appellate remedy. Tribunal is an appellate remedy. Cannot function as 226, 227. So it's an appellate remedy. It's a court of first instance. So if it is a court of first instance, so if without going to that, all these hierarchy of those forums, if it is patently without jurisdiction, under this, if a case falls within those 4 exceptions, why a writ petition according to you is not maintainable? My query to all of you is that nobody is disputing that there is a tribunal constituted. These are the issues which fall within the domain of the tribunal. These are not on dispute. The only thing is that whether it takes away the right under Article 226 or 227, then if that is not there, if ex facie Section 5 application without giving notice, if it is allowed, whether such a type of order can or cannot be assailed. That's the only issue. Nobody is disputing this tribunal is functional. These issues can also be assailed before the tribunal. But whether the High Court's power is taken away by that, that's the only simple question to you, to all of you, to address. So any other judgment, Mr. Bhattacharya? Yes, Mr. De.
My lord, on the first occasion, my lord, I have stated that according to the provision, my lord, the order is palpably wrong. That is not the, that is why. If the order is palpably wrong, it's without jurisdiction. Why should a person be relegated to the tribunal when 226, 227, the High Court has the power to interfere if it's without jurisdiction, patently illegal, without requiring any adjudication on facts? My lord, for that reason, my lord, there is statutory bar is there.
All statutory bar, all statutes. Even then, there are line of decisions which says,
yes, my lord,
even then, under certain circumstances, it can approach 226.
My lord, L. Chandrakura specifically state that is the first instant of the
court of first instance.
Court of the first instance of the same, my lord. So, my lord, he must go there. But your lordship, my lord, took that point that if the order is palpably wrong, what is the, my lord, on that point, there is no any, I could not get any judgment to same point, that is a order which is palpably wrong, whether the 226 in single bench is
that has to be decided. What is your answer on that? Make submissions on that. Because first is whether 226, 227. Second is whether before the single bench.
Yes, my lord.
What is your answer? None of you have addressed on that issue.
But my answer is that, my lord, that is the, whatever may be that, my lord, that the they should not come before the Honorable Court in 226.
Yes. So it's a fixed matter. It was fixed at his instance. He knows this. All these matters. Then I'm closing the argument. Ask him to come. Send for someone. Please start. Please make your submission.
Kindly allow me 10 minutes so that Mr. Roy can come. I can
Please continue.
Okay,
please continue. In the meantime, Mr. Rai will join. He knows this matter has been fixed. I've allowed them to make submissions. Yes, please start. Yes, ask him to come by 3:45. Otherwise, I will close. Yes. Please call the next matter.
Do you wait then, my lord?
Yes. Indication here. Decision of L. Chandrakumar's case.
Yes.
And what are the answers to the decisions which Mr. Rai has submitted? None of you have replied to that.
My lord,
there are direct decisions on that.
My learned friend assured me that he will give the all the.
But these are reported decisions.
না না এটা
These are reported decisions.
This is L Chandra Kumar. Lord, this is L Chandra Kumar.
Yes.
চন্দ্রকুমার সরু
হ্যাঁ, এটা একটা অন্য অ্যাপ থেকে মানে এসসিসি থেকে না। হুম। After L Chandra Kumar, my lord, the Article 323A and 323B has been newly interpreted. My lord, there are high courts, my lord, where the writ petition is usually heard by a division bench. And the my lord,
Sir, what is your reply to this judgment which was referred to on the last occasion? This is a division bench judgment. I am bound by this squarely on this issue. None of you have addressed. Mr. Ayaz referred to this on the last occasion.
কোনটা বলো তো
2014 সমীর সরকার
Samir Kumar Sarkar versus State of West Bengal.
There also, Section 5 was allowed without serving any notice. Directly, it was set aside.
in WPRT.
Yes. There are two things. If please see the observations, could not have been done without jurisdiction. If it is without jurisdiction, why not directly? Why they have to go before the tribunal, thereafter approach this court?
My lord, in every case, my lord, there is, my lord, there is no any necessity of LRTT.
Under certain, that is what I want you to address.
That is, my lord,
That's
if that is so, my lord, if everybody.
Where is L. Chandra Kumar?
I've given it to your lordship right now. I've given
Yes.
it.
Oh, this is not the SCC version.
No, this is not the SCC version.
My lord, your lordship can take mine.
You have the SCC version.
Yes, my lord.
Right.
এটা কি দেখে একটু
দেখি এটা পড়ে আচ্ছা নিন চন্ডিতা পড়ে নিন তারপর
Mr. Rai, this is not expected. A matter is fixed. You know, in your presence, this matter was fixed. Mr. Rai, this matter was also fixed in your presence. This matter specially I have fixed for deciding this at 3 p.m. Yes, please make your submission.
So earlier I have submitted to your lordship regarding the what will be the effect if the principle of natural justice has been violated.
That was something else. Three components are there mentioned in Supreme Court, where it says you can make or approach before the Honorable Court under 226. An alternative remedy is not a bar. Now, in view of the provision as laid down in the statute itself, whether by way of the judgment which is reported in L. Chandrakumar case, single bench jurisdiction has been taken away by the tribunal or not. These are some and substance of my argument.
The first is, Mr. Rai, I'm quite conscious of that proposition that mere availability of an alternative remedy is not an express bar upon the High Court in exercising jurisdiction under 226 and 227. Now, let us take a hypothetical case. A suit is decreed ex parte without issuing any summons. You can also challenge under 227 that decree saying that alternative remedy or a remedy provided under the Code of Civil Procedure cannot take away the right of the High Court under 227 to set aside that order if from the materials it appears that summons has not been served.
Yes.
So 227 can also be invoked in that case.
Yes. Now, my lord, the remedy is, if you're looking at the statute, the provision has been laid down. What will be the scope if no summons has been served? If no summons were served, my lord, the procedure laid down in the statute itself, the civil procedure self-contained statute, my lord, either you have to
all
avail.
statutes are self-contained.
But here, my lord,
because here also tribunal, it says any order that you can challenge. So remedies are there. Remedies are there. It's not that you cannot challenge that order before the tribunal. There, remedies are available under the Civil Procedure Code. Here, remedy is available under the Land Reforms and Tenancy Tribunal. Because suit, if it is a non-service of summons, you can say, yes, a decree has been passed. Look, I have got this order. It is on the face of it that the summons has not been served. Let us take an admitted case that the summons has not been served.
What is Honorable Lordship, whether
if
I can
only
approach
why
227?
those Order 9, Rule 13, those longest procedure, everything has to be decided, then appeal, then you come. Straight away 227 can be challenged.
That
can be challenged.
That I have to consider that way also. But here, my lord,
you make that submissions, I will be accepting your submissions on that.
But
if not,
then how you can avail this? So this is the question which comes up for consideration. Now, before that, I want to submit before your lordship whether the jurisdiction of the single bench or the division bench.
That will become. I will come subsequently. Please address me on the first issue, then single bench or division bench.
Then alternative, if you're logically
alternative
remedy.
Yes, alternative remedy is not an express bar. So remedy provided under the statute, even Civil Procedure Code, cannot take away the right of the under 227. So that can be done.
That is superseding power to that extent. Has the 227 to what extent can constitute as appellate jurisdiction, though it
not
is
appellate jurisdiction.
So
227 vast power. So it can be done. Availability of a remedy under a statute, you can waive under certain those 3 or 4. So I have given you an example of one of those categories.
Then, my lord, if you logically consider whether availability of the alternative remedy is absolute bar for the exercising power under Article 226, I put this question to myself. Then the Honorable Apex Court says it is not an absolute bar. 226 and 32, probably these are the and 227 also is the.
That is why I have taken the example of 227. 227 also.
That is why I mentioned 227.
Yes.
So therefore, one of the available.
Not an express bar.
It's not an express bar.
So it can be done.
So it is a self-rested on the part of the court to whether I'll avail that provision or not. It is not that I am not able to entertainability and maintainable to standing on two different footings. Whether by filing this application, whether it is maintainable or not, whether the court will entertain it or not.
That's the discretion.
That
That's
is the
the
discretion. That is why, my lord, I am submitting. If I can prove that these are the rules of the fundamental rights which have been violated, I can file, if you logically consider 32, Article 32 and 226. There is no bar to move under Article 32.
No bar under 227 either, so it can be done.
So
Decree
it is
can also be challenged.
I could have
Any decree, anything without availing of those recourses can be directly, has to be expanded to 27 scope.
Then it is beneficial for everyone.
Yes. May not be beneficial in all cases, Mr. Rai.
Depends. Now one can consider that. My lord is saying that way. That is why maintainability or entertainability. Whether the court will at all entertain an application in the ability of the alternative remedy, or court will self-restrain himself, though it is not an absolute bar, but court will self-restrain from exercising that power. My case is that there is a violation of principle of natural justice that categorized as a violation of the fundamental rights. So whether, my lord, I am debarred from moving this Honorable High Court or not, if I am able to prove that my right has been infringed, the fundamental rights have been infringed, whether then also I have to knock to the door of the alternative remedy by tribunal. And whether the single bench power on Article 226 can be exercised by the tribunal as if excessive power Article 226 by single bench power.
What is your answer to this?
So my respectful submission is that if I can prove there is a violation of principle of natural justice and other categories of duty of fundamental rights, the person can file an application before this honorable court under Article 226.
Yes, before where?
Now, my lord, this clearly came up whether it is an order. My lord is thinking L. Chandrakumar's case, my lord. If your lordship can consider this, I'll come to that also. With this honorable court, it was also came consideration. The honorable court says the court of first instance. If you logically consider the word what is troubling your lordship is the first. I have many blocks out of that one. The court of first instance. The court of first instance means there is adjudication by the tribunal, because previously why this was made, because it was came for consideration before the judgment which was there.
Sampat Kumar.
Sampat Kumar. It was the first.
That's the initial judgment.
Which raising the doubt.
Thereafter, that was a 5-bench judgment, then 7-bench judgment, L. Chandra Kumar.
Why? What
that
is
was the 5-judge-bench judgment.
That is why it cannot say that you cannot curtail the. What is that? Is why
there it was said it was a substitute.
Here, is a supplement.
That is
the distinct supplement. If the word supplement has been introduced, what is the reason for supplement? It cannot take away anything. Supplement is in addition to. If this is addition to, whether it takes away the power of the article by the exercised by the civil bench. Then there is, if the Sampat Kumar's case I am considering that way, then it is said it is substitute the single bench.
No, Sampat Kumar after L. Chandra Kumar, you have to know.
Why precisely my lord Ashish Rai? I put this as Ashish Rai. What is this? That is a supplement proceedings. It cannot be termed as substitute proceedings. If it is supplement proceedings, my lord, can you consider what is the word supplement under the law? In addition to, not in derogation. If it is addition to, it is a right of choice of the parties to avail them. There I can ask anything. If my rights has been infringed in that way, whether I am debarred from this honorable court, so logically consider once.
Please give me 1 minute. Let me check one date first.
মোটামুটি জাজমেন্ট দিয়েছে কোথায় দিল না বললেও না
Right.
You agree?
Yes.
No, if is there a query manner, I can.
No, I will. You make your
lordship-
submissions, I will put the query at the right stage.
and put the thing at the right time, at the right place. Now, so therefore, but if you logically consider the malt sugar and energy limited to 2022 60 Supreme Court cases page 428. I am drawing lots of attention.
Where is that?
Yes, I'm handling it.
For what proposition?
What is the scope of alternative remedy? To what extent the bar can be created? Number one, it is a late, but after that, considering all the judgments, this is a serious big judgment. Where your lordship, my lord, can you consider?
And what statute?
This is, my lord, it comes within the Electricity Act. This is a provision for tribunal.
No, what proposition you are
Yes,
citing?
alternative bar. Alternative availability of alternative remedies, to what extent can be created a bar? Or that. Paragraph 20 onwards, my lord. 2020 to 16 SCC page 428.
আমিও মানে মাথার উপর দিয়ে বেরিয়ে গেছে এত
20 onwards, my lord. Your lordship, কথা বলতে।
Yes, Mr. Rai. Industries has been considered, that's the.
And considering all the, why I was saying all the judgments at that stage, my lord, all have been considered in that way.
Yes.
So without going to other aspects. So
No, Mr. Rai, there is no dispute with regard to this proposition. Alternative remedy is not a bar.
now what is the single bench judge? The jurisdiction of a single bench. But so far, I asked the candidate lordship, that distinction I could not find anywhere. Only thing I can find, whether there can be a class within the class.
You could not find any judgment.
I could not.
Now I am putting you this question. Please now take up the West Bengal Land Reforms and Tenancy Tribunal Act.
দাও না দাদা এই তো রয়েছে এখানেই তো আছে
What is the effect of Section 8?
On and from the date from which the jurisdiction, power, and authority becomes accessible under this Act by tribunal, the High Court, except that the court exercises writ jurisdiction under Article 226 and 227, the Constitution by division bench, or any civil court except the Supreme Court shall not entertain any proceeding application, exercise any jurisdiction, power, or authority in relation to adjudication or trial or dispute or application relating to land reforms or any matters connected.
No, you need not place that. Now,
So therefore,
Mr. Rai, let me put my question so that it will be easier for you to answer. So here is a case. The statute preserves the right under Article 226 of the High Court, that is preserved under Section 8, but before the division bench, not the single bench. So it's not a case that the right under Article 226 is taken away. That's preserved under Section 8. What has been taken away or what has been excluded is the single bench power to exercise under 226 in respect of these matters. What's your answer to this?
Yes, today I have a handicap. My lord, the judgment has not been signed. The same question court of constitution is the state administrative tribunal. Because though it is not functioning, so writ application was filed.
That's a different thing. Non-functional.
Yes, that is why, my lord, not functional is something else.
Which has not been signed.
The judgment, it has held that irrespective of fact, it will be heard by the single bench. Why, my lord? It is the order irrespective of the subject. This is the adjudication instead of the subject, not adjudication instead of the order.
No, where is
Yes,
the order
yes.
passed by?
Just show the word change yesterday.
Whether these provisions were considered.
That is what, well,
Mr. Rai, this exclusion,
this
this has to be given an interpretation, and that is on Administrative Tribunals Act.
yes, there is also provision.
So, Mr. Rai, there, the entire power under 226 of the Administrative Tribunals Act was taken away by Section 28 of the Administrative Tribunal Act. Now, that went up in challenge in L. Chandra Kumar's case. It was held, no, the High Court's power, because only the power of the Supreme Court, appellate power of the Supreme Court from the tribunal was only preserved under Section 28. The power of the High Court under 226 was taken away. That was read down in L. Chandra Kumar by saying, no, yes, 226, but only by the division bench. So
Yes.
there also, the Honorable Supreme Court being conscious of the fact of the High Court's power, considering the provisions of a particular Tribunals Act which took away the power of the 226, only preserved the power of the High Court under 226 to be exercised by the division bench, not by the single bench. And that judgment was delivered, L. Chandra Kumar was delivered on 18th of March 1997.
Yes, after
That was taken care of in the West Bengal Land Reforms and Tenancy Tribunal Act because it's a subsequent legislation after delivering of the judgment of L. Chandra Kumar. This is sometimes on 12th of December 1997. So being conscious of the decision of L. Chandra Kumar, this section 8 was incorporated excluding or the power of the High Court under Article 226 of the single bench, 226 and 227, only preserving the High Court's power under 226 and 227 with the division bench. This is the Tribunal Act. That's the, so it's not that 226 powers have been taken away. Statute preserves the High Court's power, but to be exercised by the division bench, not by the single bench.
Can you consider section 7 once?
Yes.
There, as otherwise provided in this act, the tribunal shall, with effect from the date appointed by the state government under section 6, exercise all the jurisdiction, power, authority accessible immediately before that date by any court, including the High Court, except jurisdiction.
Everywhere, this division bench power has been saved.
After that, my lord,
Yes.
exercised by a division bench of the High Court, but excluding Supreme Court.
Supreme Court.
That is
Supreme
the-
Court's power, nowhere it has been touched, neither in the Administrative Tribunal Act.
What the adjudication of the
These
trial
are the matters with regard to the land
if that
reforms.
be so, whether it is not a substitution of the power, substitution of the jurisdiction.
That is for you to answer.
That is-
Because here, Mr. Rai, it's 226. Even if I take your submission, 226 powers have been reserved, but only with the division bench, not the single bench.
That is what, my lord, that is the substitution. What is fallen from your lordship, if it is a substitution of power, it is a substitution, not supplement. If that be so, my lord, can you consider why the Ashish Rai was considered to be a validation and what is the reason?
Yes. Ashish Rai.
Ashish Rai, my lord, after that, my lord, that bunch, Ashish Rai,
In this bunch, everything has been given.
Ashish Rai, also in the last part of the Ashish.
Yes.
The Ashish Rai, my lord, can you consider the last paragraph?
এই এখানে এদের আছে financial reconstruction.
It is not need to be tribunal, like the proposition is whether that is there or not.
No, no, no. For a different reason altogether.
না নেই বন্ধ দিদি আমি দেখতাম
Yes.
so therefore my submission is whether by section explaining section 7 and 8 can constitute to be a substitution of the power of the honorable single judge because the honorable apex court said it is not a substitution but supplement. Precisely that was the argument which I have advanced to your lordship.
Yes.
So therefore my lord, section 7 and 8 and considering the judgment regarding when the vice was challenged, the reason laid down or the ratio the honorable apex court said is as it is a supplement.
Then it will be contrary to section 8.
Yes.
But that cannot be done. Mr. Rai, while interpreting, all the sections are to be considered.
That is why the
So what was the object for what
that's why Royal Lordship is the object itself. And considering the object, the statute was declared to be ultra vires by holding the law laid down that it is a supplement jurisdiction. Ashisha is there, my lord. If your lordship, দাদা তোমার আসছে এই কপিটা এখানে আছে
এই তোমার কাছে আছে তা
আচ্ছা আমারটা কোথায় সব হারিয়ে গেছে
Yes, yes. Yes.
আমারগুলো দিয়ে দিয়েছি সব
State versus Ashish Rai.
yes yes yes
Yes.
may I get a copy of, because earlier I have handed out to your lordship.
You have given, but it has been tagged with this.
No, ওর মধ্যে
Then you have to take my file.
কতগুলো জাজমেন্ট দিয়েছিস স্যার
আমি তো অনেক করে দিই
হ্যাঁ আমি আগে তো দিয়ে দিয়েছি দিয়ে তুমি বাচ্চা দিয়েছো তো
State versus Ashish Rai. Yes.
নিয়ে রাখো
দিয়েছি সাহেবের
ওটা মাইলরে তো
Give it to me.
হ্যাঁ ওটা মাইলরের ওটা দিয়ে দিই
if you lost
Take it and use it in another matter. Yes, yes, yes.
paragraph 25 my lord.
Ashish Rai.
Yes, yes.
25, yes.
Clause 3 provides that the law made under clause 1 inter alia may exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court and article 133 etc. all or any other matter falling within the jurisdiction of the said tribunal. In view of the profound in S. Sampath Kumar case and reiterated subject to qualification of in Chandra Kumar's, it is a validly constituted tribunal under Article 323B could be taken away some of the jurisdiction of the High Courts. Manakali, pause there for a moment. In the instance that the tribunal has been constituted under the West Bengal Tenancy Tribunal Act and it has been given the jurisdiction to entertain dispute with regard to the 5 specified acts. Learned counsel for the respondent argues that the tribunal contemplated under Article 323B read with clause 1, read with clause 2D can only be tribunal for deciding disputes or matter in respect of the land reforms by way of acquisition of any estate as defined in Article 31A. Article 31A itself defines expression estate in clause 2. Both Article 31A and the definition of estate in clause 2 of the 31A have received judicial interpretation by constitutional bench of this court, while uniformly taken the view that protection of Article 31A is available only to the laws which are intended to carry out the agrarian reforms. The predominant purpose for subclause D of clause 2 of the Article 323B is to constitute a tribunal only for respect of pertaining to laws carrying out the agrarian reforms. Out of the 5 specified Act of the Land Reforms Act, Ticket Act, Manada is skimming about the same. Therefore, the tribunal, last 4 lines, constituted to deal with the acts cannot be tribunal within the meaning of 32B2D of the Constitution. Hence, the Land Council contained the impugned of the impugned act is not immune from challenge on the ground of violation of constitutional provision. I can turn to paragraph 21 once.
21.
20, 21.
20.
20 and 21. It starts from at the top, my lord, you'll find the same page, my lord. The learned counsel of the respondents have faintly argued L. Chandrakumar itself holds that the legislature has no power to exclude the powers of High Court on Article 226 and 27, and the direction given in paragraph 98 and 99 were merely reiteration of the principle of exhaustion of the other remedies. We are unable to accept this contention. My lord, the reasoning is paragraph 21.
Yes.
After analyzing the constitutional provision, the constitutional bench of this court pointed out Article 323A and B and Clause 3D of the court and the Supreme Court on Article 226 and 227 and 32 of the Constitution were unconstitutional. The constitutionality of the state provisions was saved by a well-known process reading down the provision. The court held, while at jurisdiction High Court under Article 226-27 and that of Supreme Court on Article 32 could not be totally excluded. It was yet constitutionally permissible for other courts and tribunals to perform a supplementary role in discharging the power conferred on High Court and the Supreme Court by Article 227 or 32 respectively. Hence, it is held that as long as the tribunal constitutes performs supplementary role.
Yes, yes.
Supplementary role
Without
exclusion of jurisdiction of the High Court on Article 226-27 and of the Supreme Court Article 32 of the Constitution, the validity of the legislation containing such tribunals could not be doubted. So I am.
Will we stopping with that? Please read the next sentence. Please read the next sentence.
In these circumstances, the direction was given.
It was in these circumstances that.
It was in this circumstance that the direction was given that the tribunal would act as the authorities of the first instance. The decision could be challenged before the division bench of the High Court.
In writ jurisdiction. So this is the composite thing. Tribunal will act as
the court upheld Section 56 of the Administrative Tribunal Act. Pause there for a moment.
Yes. So now Mr. Rai, pausing there for a moment is, so here you get an answer. Whether complete exclusion, no. As the first instance tribunal, that order can be challenged in 226 before the division bench. So this, in a way, does not take away the power of 226. So it's only preserving the division bench power under Article 226. Here is the answer. It has been quoted. If you see paragraph 99 of L. Chandrakumar. Yes. So this is the object. So that is why after L. Chandrakumar, because there it was said, it was read down, section 28, because there the entire power of the High Court was taken away. So after that, but this Land Reforms and Tenancy Tribunal Act provided that preserved the right of the High Court division bench under Article 226. After saying supplement, what is supplementing? This is supplementing. Supplementing is in a way, court of first instance, the tribunal, division bench in 226. This is the supplement relationship between this tribunal and the division bench in types of land reforms matters.
হ্যাঁ দিয়ে দিচ্ছি, দেখেছি আলাদা করে দেবো বলে। আমাদের
Yes, Mr. Rai.
Now, what is from your lordship? This is 2025 Supreme Court held that a writ application has been filed on the ground, and it was held, though they are not the party to the proceedings, violation of principle of natural justice, but you have to go and approach before the tribunal. This is 2025 INSC 1242.
Which paragraph, Mr. Rai?
Last, your lordship, just now.
This was of which act?
This is
Administrative Tribunal Act, Karnataka. There are also similar provisions.
Similar provisions.
Division bench rights preserved.
And it was held that.
Mr. Rai, any discussion on that exclusion part?
I could not find that. None of the judges I asked with. Now, my lord, everything is over. I must be candid, Your Lordship, I could not
I
find.
wanted to have something on this exclusion part.
This exclusion part, my lord, I have tried my level best. I don't know. I can invite my learned friends also, but I could not find out
The
this.
effect of that exclusion clause.
What this, because I want to argue that says this will be a class within the class. Because it is permissible.
But what is the object, Mr. Rai?
That is why the precisely the object was that. That is why, my lord.
Implementing this is the structure. Structure is adjudication will be by the tribunal. Thereafter, it's
By way of the
appeal.
division bench.
Ah.
My lord, can you consider
That's
today?
226 and 227.
Today, that is why I want to draw a
That's why it's not an appellate forum. Because under some statutes, you will be finding high courts have the appellate.
The revision
Here-
is used by the division bench.
Yes. But here it has been said 226 and 227. It's
But this, if you logically consider, then my lord, a court division bench has the power or to exercise under 227 the single bench. My lord, can you consider that?
then, Mr. Rai, there may be
Constitution does not say so. If you logically consider Constitution of India, this is a court, not the bench.
But yes, no dispute. But you have to read this provision in that line. Here it says it has taken away the power because 226 has been given to the High Court. So you may, in some cases, you will be finding some 226 matters are being delegated. That's the roster.
That's the
This
roster.
roster. So those have been assigned only to the division bench. Some matters to the single bench. But when under some statutes you will be finding that this has to be heard by the division bench.
Yes.
So then it has to be heard by the division bench, even if it is 226. So this is something is on roster. It can be given to some, but if the statute says it has to be by the division bench, then it has to be by the division bench. So here the statute says
Division bench.
226 is by the division bench.
Then the original exercise.
So yes, so all matters with regarding to land reforms, even 226, you have to directly approach before the division bench because single bench jurisdiction is excluded. Now, one avenue may be open in case where the tribunal may not be functioning. We are not
So
here.
that is why I have to draw lots of that
We are
judgment.
not here. No. This is not that issue.
No,
That
this-
can be
that-
decided.
This is the
That
subject
can
matter.
be decided in another
No,
matter.
no. I'll bring that judgment before your lordship. My lord can pass any judgment today or day after tomorrow. I'll produce the judgment. My lord, can you consider whether it is a subject matter? Then, my lord, the land reforms under the any issues under the land, if the tribunal is not functioning today, then what will be the problem?
That's a different thing. That is why I'm not touching that issue because that is not the case here.
My lord is considering that way. That is the tribunal takes away. So therefore, my lord, if it is not functioning, does not mean the statute
That's a different thing. I will
that requires to consider it that way also.
produce the judgment because I have a ready-made answer, but I do not want to.
My lord is
The judgment, Mr. Rai, which you are trying to very ওইটাকে কোথায় জেএম ফিনান্সিয়ালটা কোথায় রাখলাম?
It is a Shah, Mr. Shah argued this matter.
No. That is on DRAT. No, not on that. This is Mr. Rai, the question which I have put to you that whether in that civil suit ex parte degree, whether 227, Supreme Court has said no. That's the distinction. That's the distinction in Tuticorin. I've considered that. So you are carrying those gadgets of Supreme Court.
No.
So 2019, if you can find out 2019. There, 2019 9 SCC 538. That was the case, Mr. Rai. There, a distinction was made. What is with regard to the availability of alternative remedy under other statutes and the Code of Civil Procedure. So a different footing. So in Tuticorin, that I have considered that decision. So there, the Honorable Supreme Court has said, in respect of the remedies provided under the CPC, 226, 227 is a near total bar. That's the language used by the Supreme Court.
Then I'm-
Please see this judgment.
Okay, because I get it.
Please see these two paragraphs where it has been quoted, where that expression has been used is a near total bar. Those quoted paragraphs. Those examples have been given. Should decree, then 227. That's the exact language. Those examples were given by the Honorable Supreme Court. You can also straight away challenge that under Article 227. Others are other matters. That was on injunction. So directly challenging that injunction, 227 was filed. And an argument was made that yes, if those are there, why not 227? So there it's a different footing, stands on a different footing. The remedies available under the Code of Civil Procedure stand on a different footing altogether. There it has been said.
The civil courts in terms of provincial civil procedure code, the remedies available under the special enactment or statutory rules.
Yes.
And the fora provided therein happen to be the quasi-judicial authorities and tribunals.
Yes.
The held therein is the case where they may involve civil suits and other proceedings with the civil courts. The ability of an appellant remedy in terms of provincial code may have to be constituted as a
Near total bar.
near total bar.
Yes.
Yes, what the hell?
Total bar. That's the language used.
So the better footing says. No, then I am in better footing. Now I am in better footing.
May I take note of it?
Not in better footing because they are for that those were the civil procedure code under that. Now you have to test that because Mr. Rai, what was troubling because I have to make my mind clear to all of you to give an answer. In most of the statutes, Mr. Rai will be finding that such and such order is applicable under such and such. In some statutes, you will be finding that the jurisdiction of the civil court is barred, the other courts is barred in this. But this is a statute where it excludes formation of a tribunal or an adjudicating forum has been constituted by this act, preserving the right under Article 226 and 227. In other statutes, you will not find that.
No,
Preserving.
This is the only
Yes. So
limitation
that is so that is here the Honorable Supreme Court was considering other statutes which provides for an appellate remedy and civil procedure code. Here we have to test those appellate remedies and vis-a-vis the provisions of this type of.
If that be so, then what will be the concept of class within the class? The basic concept. I am going to the basic concept.
It's not a class within a class.
Yes, this is a class.
Single bench.
Division bench.
It's not a class within a class because then Mr. Rai, you have to challenge that statute. Unless
That's
you have,
why. Then what?
here it has been preserved as it is because here, Mr. Rai, what was previously done prior to this Land Reforms and Tenancy Tribunal, let us not go to the administrative, same thing. Single bench, you have filed the writ petition, then intra-court appeal before the division bench. So you are getting two forums before the High Court. Now, to lessen the burden of the High Court, this adjudicating, because appeal, then it was an intra-court appeal, then it was not 226.
That is possible.
So it was an intra-court appeal. So it was a concept of appeal. It was not 226 then. So it was a mandamus appeal. It was styled as that, not 226. Appeal arising out of an order, but it was not a direct 226. Here, now, this power, it was taken away. The single bench, what was decided, initial adjudication was given to the tribunal. Now, against that is not an appeal. It's again 226.
Ordinary jurisdiction.
So 226, what was initially exercised by the single bench, now by taking that, it has been given to the division bench. It's not an appeal. So it's not a class within a class. There we were not getting 226 forums. You are getting 1 226 and an appeal therefrom. Here you are getting 226. An appeal is a creature of statute. It can be taken away.
Or
Yes, can be taken away or conferred. So you you cannot say, yes, initially I was having an appeal. So now,
the creature of statute, it can
yes,
be
the
conferred. or
iris of
rejected.
section 28 of the Administrative Tribunal Act was declared as ultra vires, or it was read down only because the entire power of 226 High Court's power was entirely taken away. There it was said only the division based power that has been saved in administrative West Bengal Land Reforms and Tenancy Tribunal Act.
Well, that portion, if you what is followed for a lordship, if that be considered in that sense, Malad can be considered in that way. Today, if due to some reason or otherwise, the tribunal is not functioning. I am on again come to that because what is followed for a lordship, I will again have to knock the door of that position. Then whether then what will be the remedy available to a person?
Bring that case when the
because
no. I'm not saying of the judgment. It is to be a case.
No, Malad is
Mr. Rai, those will be obiter.
Not
that will be a obiter. So because here we are not concerned, that will be an obiter. So here we are concerned with a case when the tribunal is functional. So what is the effect?
To entertain the original.
Yes, by passing a remedy under a statute.
7 and 8.
Yes. So I'm not saying whether 226, those propositions of law, that availability of an appellate remedy, whether that can be borrowed here or not, that's the only question. Because that's not disputed. That proposition cannot be disputed. There is no quarrel to those propositions.
No. What is followed lordship? It is the by statute itself.
Yes.
Reserve that.
Yes. By statute, it is taken away. Not taking away, preserving to some.
Yes.
It's a division bench. You will find in many statutes, it has been said it is to be heard by a division bench. This appeal is to be heard by a division bench. This is to be done by this.
Tribunal case.
Everything.
Or minor can consider the Hindu Marriage Act. If that be so, my lord, I want to consider only one day, my lord, that's the judgment. If anything, I can appraise your lordship.
Which judgment?
That in absence of any tribunal.
No, you appeared in that matter.
No, it's slightly appeared because this was the matter. What he has this thing to argue over there.
No, Administrative Tribunals Act, if the
object, I want to go to by the object. For reduction of the burden of the High Court.
Yes, that's exactly.
But it does not exclude that word that 226.
L. Chandra Kumar.
Yes.
That's the exact.
98, 99.
Yes, 98 and 99. These two paragraphs, and also I've relied upon, but I thought that would be challenged before the division bench, but Mr. Mojumdar has not challenged that. Because there also have held its division bench.
Yes.
It's also before the division bench. So I thought that it will be challenged,
No,
but
I had a talk with Mr. Mojumdar. He said,
no, he came. I told you.
There is no instruction.
He has accepted that.
Yeah,
He has accepted and approached the division bench.
But there is only one judgment, but it should be brought to my lord's notice, but it can be distinguished on facts itself.
Which?
The division bench in 2023, 3CHN S19. It can be distinguished.
Justice Mukherjee's judgment? No, that was from WPLRT.
No. Subject to
This judgment. No, I was thinking of Justice Shubhra Kamal Mukherjee's judgment, which we have relied upon. Facts were same, but it was from WPLRT. So
yes,
I have seen that. Those points.
The judgment.
This is on what?
That whether this honorable court and the can entertain an writ application.
No, this was before the division bench.
Yes, it was subsequently went up to division bench and it was held.
Oh, initially single bench.
Yes.
And
after the division bench.
So from where?
226 single bench.
No, with regard to what issue?
West Bengal Land Reforms sensitive, there is an order subject to question, that was the issue. alternative remedy. What is the argument of your lordship that was considered and held to be the. So it can be, there are no provisions was considered in that sense.
No, L. Chandra Kumar considered,
Yes, 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 yes.
not in that line.
Discussion,
Because those provisions 6, 7, 8 has to be read. Because the meaning has to be given to all the provisions.
That is why I bought your lordship's notice only on the ground, whatever will the, otherwise there will be conflict of something. Somebody will place this one, single bench will abide by the judgment, the division bench will consider in that way also. So that is why I bought your lordship notice to consider the same also.
Scale of pay, administrative tribunal.
Yes. Oh. So that is why we have what El Chandra was considered what reasoning is given the alternative remedy.
So there the tribunal was in functional or not functional?
That was not there. Well, that is not mentioned in that sense to that extent, my lord.
Direct challenge to the. Mr. Rai, was any point of jurisdiction taken?
At that point of time, no.
No.
But even if after that the order of decision is just conscious, it says even if the jurisdiction was not taken at the threshold, but does not denote the power of the decision
taken at the
can be
subsequent
taken
stage.
at any point of that was considered.
But this was subsequently the division bench which was taken up. The
Distinguishing while if
yes. Yes. Anything in reply?
Oh. Yes, practically whatever point I have to take, that has been taken by your lordship.
What are you saying? You have not taken any point.
My
You
lord,
have not taken any point. You went only on the delay ground.
no, that subsequently that
To make this
single bench division bench that has been right.
any submission.
No, yes, but my lord has pointed out section 8. That is very clear. Taking
While countering Mr. Rai.
While
countering Mr. Rai.
That
have not made any submission.
No, that I have
you have submitted delay.
Because
Tribunal cannot be done.
I got that recapture joins judgment and I thought, my lord, that will
is the issue.
Now, but as regards my lord, that single bench that has rightly pointed out that these two incident, my lord, that one is my lord L. Chandra Kumar's case, and after 2 months, this.
Now I have not made up my mind.
No,
to see what points he can make.
As
My lord can disturb.
okay. No.
Yes, Mr. Rai, when he will be getting that Jackson?
I have heard that it will be signed by today. Tomorrow it will be in forward.
So I'm keeping it tomorrow.
Not tomorrow, my lord.
Or
My lord, 2 and 4.
No, instead of let it on Monday or Tuesday.
কালকে আমরা অন্যদিন জলসার ওঠে না কালকে আমরা
কালকে কেন বলছো?
কালকে না, কালকে তো চিফ জাস্টিসের ইয়েটা যে সকালে সোয়ারিংটা
তারপরে তো চলে যাবে সব।
You can supply me the judgment. You want to make any submissions on that?
Only if I come back to mention on it, but if I don't have any submission, I will not make it.
Well,
What I have made, if I found any
I would get the weekend, Mr. Rai.
There was my lord will be very busy over there. No, my lord will be very busy over there. There are other matters too.
Forget everything.
দিয়ে দাও না।
That sort of memory that I can impress.
Mr. Rai, do you want to file any short note?
No, notes.
If you want, no, Mr. Rai, if you want, because this is an issue. If you
That
want,
is why I want to draw your lordship. Only one day.
I can give you all of you, not only.
Then my lord, I'll allow with the judgment I filed. According to my capability, whatever submission I made, only point wise I will not make.
Don't make it a bulky because
Bulky
this is
only,
the only issue. Because this is an issue.
Which will now it will be the power of the High Court under 226, and now it will be considered in that way when the tribunal is not in session.
Now I am sure it will not rest here. It will go somewhere up. So we'll get a either way. Either way, it will.
Not all the judgments, my lord. My lord is thinking that way because
No. But this is an issue which is to be settled.
that is why I consciously have handed over the judgment of the division bench.
That is why I am telling you, because this is an issue which has to be decided
That
by
is
a
why
larger quorum.
that is why I have handed over to lordship the division bench judgment, because this is going to be considered as a whole, because unless until these are all the judgments we consider by, otherwise it will be again, my lord, these are the judgment which is there left out, not considered division bench, single bench pass. That I, though it is in my favor, I did not disclose the same at the initial stage. Though it is in my favor, but I did not disclose it.
Because you know the points of how it is can be distinguished. Because you,
Ultimately,
No.
that is it.
Ashwin. Notes you can submit.
Yes, yes, yes.
19th, it will be open to the parties to file a written notes. Any points which you want to rely upon? Kivalam?
Be permitted to submit one thing, my lord, because this is regarding monthly list matter of item number 35. Actually, on the 5th, we waited entire day, and today we were engaged, both my junior and myself were engaged in another court, and the matter has been disposed of. Kindly, my names may be included.
All right. 35 you are for the petitioner.
I'm no for the state respondent. Kindly, please accommodate, my lord, please. Please, I beg of you. And I'm the